Ms. Messina, can you start us off with a roll call, please?
Good morning, Commissioners. District 1, District 2, District 3, District 4, District 5, District 6, District 7, District 8,
She's here.
District 9, District 10,
Present.
District 11, Shh. District 11, vacant.
Vacant.
District 12, District 13,
Here.
District 14, and Place 15.
I'm here.
You have quorum, sir.
We do have a quorum. Good morning, Commissioners. Today is Thursday, April 4th, 2024 at 9:02 a.m. Good morning. Welcome back, Commissioners. Have a good docket today. We're going to jump right in for questions for staff, and we'll begin with case number 2. That one is as brief as needed. Let's table that one just for just a second. Give Commissioner Kingston some time to come in. We'll come back to that one. And we'll jump into the consent agenda, which consists of cases 3 through 6. 6 has come off consent because there's some boxes in there. So we will take that one off consent and dispose of it individually. Takes us to case number 3 in District 8. And Mr. Pepe. Good morning, sir.
Good morning. Let's start with item 3. Item 3 is Z223-198, and this one is located south of I-20 on Bonneview Road. Application, and it's an application for an LI, Light Industrial District, and 2, a specific use permit for commercial motor vehicle parking on a property zoned in AA Agricultural District on the west line of Bonneview Road, north of Logistics Drive. It's about 3 acres. Purpose of the request being to allow commercial motor vehicle parking on the site. And here's the site as it exists today and its surrounds. So current zoning is ag. There's light industrial PD to the east and the south. There's CS general districts with SUPs for commercial motor vehicle parking to the west. There's one ag parcel to the north and some LI to the north. That proximity to a couple remaining ag parcels necessitates the SUP. And it is only accessed from Bonneview Road, but generally it's industrial in character or entitled as such, but they do need the SUP due to some ag that exists in the area right now. Here is the property looking west on Bonneview, looking southwest, looking south. It just started raining in this photo, it looks like. That's great. Southeast, the warehouse in the industrial PD across the way, and looking up Bonneview, looking back. So as for the development standards, we've got ag at this time, and they're proposing LI. There are definitely some restrictions on the LI due to the proximity to the A and sharing a block face with A. Here's a site plan as it's proposed. And so I am talking about yours. So basically, it shows their commercial motor vehicle parking. They have a small office building on the site as well. And they do have to put in a 50-foot setback due to the block-based continuity with a district on the block. And staff recommendation is for approval of 1, the light industrial district, and 2, the approval of the specific use permit for commercial motor vehicle parking for a 5-year period, subject to a site plan and conditions. Here for any questions.
Thank you very much. Questions, commissioners? Any questions on this item? No questions? Thank you, Mr. Pepe.
Good morning. This is the 223-236. And this is an application for an amendment to a specific use permit number 2337 for the sale of alcoholic beverages in conjunction with a general merchandise food store, 3,500 square feet or less on property zone a regional retail district with a D1 liquor control overlay. The purpose of this request is to allow the continued sale of alcoholic beverages in conjunction with a general merchandise food store, 3,500 square feet or less, is located at the southwest corner of Great Trinity Forest Way and Murdoch Road. This is the zoning map. You will see it's surrounded by retail uses and also a motor vehicle fueling station. Outlined in blue is the area request on the area map. They renewed the specific use permit. Well, it was approved on June 12, 2019 for a 2-year period with automatic renewal for an additional 2-year periods and for the use of sale of alcoholic beverages in conjunction with a general merchandise food store, 3,500 square feet or less, and the applicant filed for a renewal of the SUP on March the 21st, 2023. The applicant requests the renewal of the SUP 2337 for a period of 2 years with the eligibility for automatic renewal for an additional 2-year period. With the exception of the time limit, the applicant does not propose any changes to the existing conditions or site plan of SUP number 2337. The next few slides will be pictures of the site and the surrounding sites. On the screen, you will see the SUP conditions, and the conditions are the same. The only difference is the time. This is the site plan. And staff recommends approval for a 2-year period with eligibility for automatic renewals for an additional 2-year period subject to site plan and conditions.
Thank you very much. Questions, commissioners? Commissioner Blair, please.
Good morning.
Good morning.
Were you aware that there is a lot of homeless activity at this location?
When I did my site visit, I did see a few homeless people.
Were you aware that this applicant, no, you weren't be aware of it because you weren't here when they the last time. So were you, but let me pose it in a question form. Were you aware that when their last SUP was renewal, it was only for a 2-year contingent on the fact that everybody on that street cleaned up their homeless and the vagrancy and people hanging out and doing a whole lot of other stuff, drinking and whatever on
No,
property?
ma'am, I wasn't aware of that.
Okay, so I looked at, and I know we're not supposed to be looking at your stats, but I looked at your stats, and it's in the the stats kind of concern me. So were you aware that there is a funeral home and a cemetery not half a mile down the street, about half a mile down the street. And this is the spot that people would get off and go down in order to get to that location?
No, ma'am. I wasn't aware that they would go down at their location, but I did notice that there was a funeral home down the street.
Okay, so, but there was, you did, when you did your site visit, there was homeless that were there,
Yes, ma'am.
and there were, it was a challenging location to view, if to say the least, if not correct?
I wouldn't say it was challenging, but I did notice that there were a few homeless people out front.
Okay, thank you.
You're welcome.
Can you take this off of consent?
Absolutely, we can.
Do you know?
They did not confirm, but I did send them several emails letting them know that the case was on the agenda today. I sent them the staff report, and I told them what time to be here, and they did not confirm. You're welcome.
Thank you, Commissioner Blair. If the applicant is listening, highly recommend you make it down here at 12:30. Questions, commissioners?
Can you call them
Commissioner Blair,
again?
please.
Can you call them again and ask them to come down at 12:30?
Yes, I'll run to my office and give them a call.
Thank you.
You're welcome.
Any other questions on this item, commissioners? Thank you very much. Good morning.
Good morning. Item number 5 is KZ 223-250. The request is an application for a plan development subdistrict for an MF2 multiple family subdistrict uses and an assisted living facility use on property zoned in MF2 multiple family subdistrict within plan development district number 193, the Oak Lawn Special Purpose District. It is located on the southeast line of Inwood Road, northeast of Lemon Avenue. It's approximately 3.035 acres. So this is the location map of where the site is at, an aerial map. The area in blue is the area of request. So this is a zoning map surrounding uses around the site, multifamily towards the north and northeast, industrial inside towards the west, as well as motor vehicle repair. And then there is a restaurant with drive-through service to the southwest, and then there's single family towards the southeast. The area of request is currently developed with several two-story multifamily buildings and is zoned MF2 district. The applicant is proposing to develop the property with an assisted living facility and a reduction in parking space requirement. The existing zoning does not allow this use, therefore they are requesting a use of district to permit this use and define terms and requirements for it. The PD condition does define the assisted living facility use as a permanent residential facility requiring an assisted living facility license from the state of Texas for all units, which furnishes in single or multiple facilities, food, shelter, laundry, and other assistance, which may include memory care and activities of daily living to 5 or more persons who are not related by blood, marriage, or adoption, the owner, or propriety of the establishment. The pedestrian realm will be enhanced by design standards that ensure safe and activated sidewalk and require below-grade parking. These are some of the site photos of the site. On-site looking southeast. Again, looking southeast. Towards the north, looking southeast. Looking southeast. Looking southeast. Looking southeast. looking northwest, looking northwest, looking southwest, looking west, looking northwest, looking northeast, looking northeast, looking northeast, looking northwest, looking northwest, then surrounding uses around the site, on-site looking southwest, looking east, looking east, looking north, and looking west, looking east, looking east, looking east, towards the south, southeast, southwest, southeast, southwest, looking west, looking southeast, looking southwest. And these are the development standards that are being proposed for the PD 193, the new PDS. For the front, they're all proposing 15-foot front setback. For the side and rear, a 10 setback. However, for below-grade parking structure, they are requiring a 0 minimum. And then for density, no minimum lot area per dwelling unit, they are proposing a 170 units max. The height, they're not doing any variances. And then for the lot coverage, they are proposing a 70%. And then this is the development plan that they're proposing. And then I did a more zoomed in. And then a staff recommendation is approval subject to development plan and conditions.
Questions, Commissioners? Commissioner Hall.
Thank you, Ms. Garza. Just wanted to clarify a few things, make sure we're all on the same page. The apartments that are on this location were built in 1948, correct?
I'm not aware of when they were built.
Yeah, 1948. That makes them just a little bit older than me. The current zoning allows retirement housing at 55 units per acre, I believe.
Yes.
Okay, and so they're asking to do 170 units in total in, is it 2 or 3 stories? I think it's 3 levels.
They're proposing, a development plan does say 3 stories.
Okay,
Yes,
but not any higher than the existing buildings or something like that?
Correct. They're keeping the same height.
Okay, thank you. Current zoning does not allow assisted living, nor does it allow kitchens.
Correct.
And so the applicant wants to provide assisted living along with kitchens?
Yes.
Okay, thank you. And let's see, what else was it? I believe they're going to do some improvements on LaFoy Drive, where the dumpster area is.
Believe they did mention.
Okay, yeah, I think they're going to do maybe widen the street or something like that, just to make it easier to get the dumpster trucks in and out. Thank you.
Thank you, Commissioner. Vice Chair Rubin.
Just a couple quick questions. One, I haven't looked in any detail at the new maps after redistricting, but when I think of PD 193, I think of District 14 and District 12, but I guess D13, D2, thank you. I haven't had my coffee yet. I guess District 13 was redrawn to get into part of PD 193, is that right?
Sorry, Can you repeat that?
Okay. 2 cups of coffee, all right. And then one other quick question on these accessory uses. It says that they're for the exclusive use of the residents. I can think back to visiting, a grandparent of mine at a facility like this, and I might go with that grandparent to the movie theater or the salon or something like that. Does this prohibit, guests and family of the residents from using that, part of the assisted living facility?
Not aware.
Okay, thank you.
Vice Chair Rubin, that was the intent, and now that I'm looking at the language again, I think we can clean it up to make that a little bit more clear, that it was for the residents and their guests. But I would defer to the applicant if that's what they actually intend, but I know in drafting it, that was what I sort of envisioned.
Thank you, Mr. Moore.
Commissioner Hampton?
Thank you, Mr. Chair. Ms. Garza, two questions. On the transparency requirements, I see that it's 15% along Inwood Road. Could you speak to how that relates to other standards that we have? It's on 512 of our case report.
I know for this one, they did mention that they still wanted a buffer for the residents there, like a transparency for, not for the residents there to have a privacy. So they did say 15%.
Okay, well, I had gone back and looked at just form-based code as a reference because I know it typically has transparency requirements, and even along primary streets, it was a higher percentage than that. So that just caught my eye. That seemed like it was a low, but certainly recognized Inwood's a busier street. Second question is, I noticed that the landscaping is called out to be compliant with Part 1, which would be Part 1 of PD 193. Could you speak to what percentage of open space will be provided? Was that information that was provided by the applicant?
Yes, they did provide.
And I apologize if I looked past it.
So they did they're providing a minimum of 3,500 square feet of open space, Mr. Perry, or roughly 27% of the lot.
And is that functional open space, or does that include all of the setbacks and other areas? I guess I'm trying to understand is what are the amenities provided to the residents that are usable open space?
They mentioned the whole entire set.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Any other questions, commissioners? Commissioner Forsyth, please.
I wanted to ask, are they tearing down the existing buildings that are on the site to build a new, or are they just renovating the existing buildings to make it into an assisted living facility?
They will be demolishing the existing buildings and building a new building.
Any other questions, commissioners? Okay, we'll keep going. Thank you very much, Ms. Garza. Commissioners, again, case number 6 has been taken off consent.
Hello again. Item 6 is Z223260, and this is located off of Lemon in Oaklawn. And it's an application for a plan development subdistrict on property zoned a GR General Retail Subdistrict and an MF2 multifamily, multiple family subdistrict within PD 193, the Oaklawn Special Purpose District bounded by Lemon, Throckmorton, Bowser Avenue, and Reagan Street, and it is 3.07 acres. Purpose of the request being to allow modified development standards primarily related to uses, setbacks, density, lot coverage, floor area ratio, height, density standards, or excuse me, design standards, parking, landscaping, and mixed income housing to develop the site with residential and retail uses. And here's the aerial map of the site as it exists today. Tried to highlight the split zoning nature of the parcel as it is, or the block. It's split between MF2 and GR right down the middle. There's an alley there at this time. There is multiple family uses to the northeast, east, some single family attached subdivisions to the east, multiple family to the southeast, a restaurant without a drive-through southeast across Reagan, and then a couple restaurants with drive-through across Lemon with an office building, retail building, auto service center to the northwest, and then finally a single-family attached subdivision to the northwest. And it is split between those two zoning districts, which separate the uses. But the change would sort of blend the development standards of those two in terms of height and massing, allow them to spread out their height rather than focusing at all 100% on Lemon, where the GR entitles quite a bit, whereas the MF2 entitles a lot less. So they'd be able to spread it out a little bit better with their development standards. They do have a mixed income component, they have design standards, and they're proposing a conceptual plan, development plan, and a landscape plan. And here's the site on Throckmorton looking south. The alley is right there in the front. And then we're going to go around the block slowly. There are some townhomes there on the site right now. Service parking. You can go around the site down Bowser. Service parking. Surface parking. Surface parking. Old abandoned retail structure. Surface parking that was associated with that. Surface parking. Some undeveloped space. There was a Taco Bueno here at one point where that tile is. There's surface parking at the corner of Lemon and Throckmorton. And turn and look at some of the surrounding uses. So there's a restaurant with a drive-through, caddy corner. There's a Take 5 auto service center across Throckmorton. And there's single family attached, some multiple family, mix of multifamily plexes across Bowser, looking at single family attached, circling the corner from Bowser onto Reagan, some multifamily, and the restaurant across Reagan. And then finally, back at Lemon, more restaurant going in, office building across the street, and another taco drive-through across the way. Here's the conceptual plan. And conceptual plan, there are some clarifications offered in the last minute changes from the docket. They are kind of administrative in nature, but at the end of the day, this conceptual plan stands to limit uses southwest of the half line to the commercial ones. GR allows multifamily in there already, and then multifamily uses strictly multiple family, strictly to the northeast. So it sort of keeps in the use regiment while the rest of the section allows deviations from the development standards of those two districts. So we end up with kind of strictly multifamily on the northeast, shown here on Plan North, and then podium parking and retail in the southwest, taking up the whole block. Another look at that. And my amateur cross section, but I did feel that was important. It steps up as it gets away from the Bowser Avenue residential part. It has to jump up for that parking podium. They have partial above ground, partial below ground, and it also jumps up to allow a little retail block on Lemon. And as for the development standards, they're highly qualified, but they have reduced setback on Lemon, keep that building closer to the street, whereas it kind of maintains a higher setback along Reagan. It also has higher setbacks to step back the massing away from the residential half of the block. As for minimum lot area, they, across the whole site in terms of pure unit count, they'd reduce it a little bit. Floor area ratio as well as other development standards may make the existing cap of 520 a little hard to hit, but we do include the total density that would be allowable on the base regimen there nonetheless, and mention the mixed income housing percentages in there. Those are subject to change in the changes of the docket. Their MIH also is tied to the base increasing from a 2.0 FAR to a 3.4. 2.0 kind of had to be a specifically set base because multifamily 2 didn't have a FAR to start with. But yeah, we see that height decrease from 85 on Lemon down to 36 on Bowser. There's the intermediate steps. And then 90% lot coverage. The whole structure allows them to enclose their garage. And as for landscape plan, they have a landscape plan which generally meets the requirements of Part 1. They have some reduced street trees along Throckmorton, provided that they preserve the existing large trees that you see there in the northwest corner, or it's actually the north corner, plan northwest. But that's the primary variation. Otherwise, the street trees and other planting groups are the same as you would see in the Part 1. They did modify the garage screening so that it doesn't overlap with 4.1107, but in this case, 4.1107 would control and allow for preservation of specific live oaks on Throckmorton. Mixed income provisions have updated in the change of the docket. The old one was 3.5 at 61 to 80 AMFI. When using a 1.4 increased FAR. The max height is tied to the FAR, but the max height actually decreased across the whole parcel. It's a slight reduction in the average height across the parcel is still tied to that. Staff recommendation 5% at 61 to 80 AMFI is based on the existing MIHDB ordinance that we use across the board, which is 5% at 61 to 80 for a 1 FAR ratio increase. And other variations from 4.1107, they meet 4.1107 mixed income design standards for the most part. They vary their active building width. The hope is that will let them use that active building a little more frequently than they would maybe screening or anything like that, and allow that retail in front of their garage on Lemon. Transparency pacing does not apply to garage parking walls. Most of that is wrapped as it is. Everything else in 4.1107 remains unmodified. Fencing, individual entries, pedestrian scale lighting, ground level open space, garage screening, all standard. And additional design standards, they have 2 pieces of street furniture from the regular mix of 3 for each frontage. They have driveway width and number maximums, so 25 maximum width anywhere, 1 per frontage on Throckmorton, Reagan, and Lemon, and then none on Bowser. Additional 40% transparency above what's called for in 4.1107. That's 40% on Lemon. Elsewhere, they're required to meet the 4.1107 transparency, which is evenly spaced. And 3-foot vertical buffers between sidewalk and parking or driving surfaces. They don't have, on the development plan, they don't have any primary exposed parking or driving spaces, but the 3-foot vertical buffers, should they change their development plan in any way to include those, that'll apply, protect the sidewalk from car encroachment, and safe crossing language you're likely familiar with. One difference in the recommendation and the request is in regards to sidewalks. So staff and the applicant are in agreement on 8-foot sidewalk with a 6-foot parkway, 5-foot parkway, it's a 5-foot parkway on Lemon. And then on the other streets, staff recommends 6-foot sidewalks across the board and a parkway minimum of 5 foot. They recommend, or they request to, shrink their driveways when they reach, shrink their sidewalks when they reach the driveway as you go northeast on the site to 4-foot minimum sidewalks, have a larger parkway. Staff recommendation is to keep the 6 across the board. And one more look at the plan, you can kind of see where they've marked their driveways on here. It's not exactly midway through the site, but approximately And then north of those driveways, they shrink the sidewalks down to 4 feet. That's a refresher on that. We did have changes from the docket, and they're mostly administrative. Some clarification on conceptual plan, just to beef up that language, make sure that it applies only to uses, not to development standards, because the whole point of the rezoning is to allow the development standards to vary across those 2 tracks, but to keep that retail component to the southwest. And so that's achieved on page 1, 2, and 3. Parking. Page 4 has detail the small loading spaces need to be on the ground floor. There were already required small loading spaces, but it gives detail as to where those should be. Removes turret from the list of public entrance architectural elements. Long story short, their primary entrances need to have architectural elements, and that was one in the list. They've removed that. And page 6 added some sustainability features like albedo roof structures, recycling, irrigation for landscaping, and bike racks. I believe it was 3 bike racks need to be accessible to the public of the overall bike parking that they have. And the applicant accepted, incorporated, the staff recommended mixed income housing units at 5% at 61 to 80. AMFI was previously 3.5, as stated a minute ago. So staff recommendation is approval subject to a conceptual plan, a development plan, and a landscape plan, and staff's recommended conditions. And I'm here for questions.
Questions? Commissioner Kingston, please.
Yeah, I just have one question, and this is probably for Phil Irwin. There was some discussion sort of late about the trees on Lemon. There was discussion with the community about them being 6-inch caliber, and I think maybe there was a recommendation by Phil that they be 5-inch. And I would just like to get some clarification about that. I don't think the developer cares, and I don't care. So I'd like to understand what he would prefer for the health of the site.
What Phil would prefer? Let me see. So the one thing we touched on Lemon was not using live oaks as the primary planting group there.
Correct.
To be a little too, in his estimation, too dense to see there, because it's a dense tree cover of the live oak, whereas we'd be able to use live oaks elsewhere. The conditions don't touch on the caliper width on Lemon.
Yet.
I can see if Phil is available, but beyond that, at the time, the proposal leaves it as the base standard, which I can't remember off the top of my head. Would you like me to ask him something specific?
Yeah, if he has, I guess there was a representation or an agreement made with the community, and I'm trying to understand. I think the agreement made with the community was that they would do 6-inch, and then my understanding is there was some discussion that 5-inch might be a better choice for those trees on Lemon to, I don't know, grow healthier or grow faster or whatever. And so I'm just looking for his professional opinion about which size tree would be best to plant from the start.
I'll see if he's handy. If not, I will get you that info before public. But just to clarify, there's not any text at this time reflecting that discussion.
I understand.
But it could be added.
Okay, thank you.
Thank you. Commissioner Houseright. Oh, Mr. Irwin.
Welcome.
Good morning.
Pardon my interruption. I thought I could step in here real quick if you can hear me okay.
Yes.
Okay, very good. The difference that we had on this was the code references a minimum of 3.5 inches. When we start escalating up to a 6-inch tree, we start looking at difficulty of planting, also the difficulty for the tree to adapt to the condition. That's a more mature tree being planted in that limited urban condition. So we look for planting 3.5-inch tree is just as substantial as planting a 6-inch tree from my point of view.
So what's your recommendation? Leave it as is?
I would typically leave it as is for code minimum and allow it to grow to the 6-inch. Now, if it's the idea is to provide the largest size possible at time of installation, that's something you can try to apply for. But for the longevity of the tree and it adapting to the location, a 3.5-inch tree, 4-inch tree maybe would be more suitable.
I'm sorry, I didn't hear that last part.
The 3.5-inch tree minimum is a good standard. If you want to go to 4-inch, I mean, it's just a matter of the age of the tree that you're installing into the site. The younger the tree, the faster it can probably grow as it's maturing into the location.
Okay, all right, thank you.
Commissioner Housewright?
I'm glad he answered that.
Thank you, Mr. Chair. Just a couple of questions. Mr. Pepe, I believe I read that there is a requirement for 13,000 square feet of ground floor open space. Did I read that right?
That's correct. It's
Okay.
ground floor.
And you're satisfied it's there because with my math skills, I couldn't get to 13,000 feet, but I'm sure you're fine. You've got it figured out?
Now, that's required by the conditions. What is leading you to?
Well, I just didn't see enough information for me to confirm that. So you can think about that for this afternoon. And then there was some language about evidently some relief to the garage screening because of landscape, and I didn't quite follow how that worked. Did I read that?
Yes. Well, it's an interaction between the landscaping in PD 193 does some things that we would call design standards elsewhere, including garage screening. They are going to meet the full garage screening requirements of 4.1107, but they get relief from the screening requirement of Part 1, PD 193, where they may conflict, and it would allow an open space. In short, they want to, and that relates to the open space. They want to put an open space outside of a garage, but if you have a garage in PD 193, you need to put, I think, planting groups in front of it, and so that would allow them to do that, have a kind of an urban open space on Lemon Avenue, and you can see that on the plan. So we're covered in status estimation in terms of garage screening, but it's sort of a interaction between two screening standards and in the mixed income design standards and PD 193. And then as for the open space is required in the urban design standards section. So for development, they have to have 34,000 square feet of total open space and then 13,000 of total open space on the ground floor. And that's required by condition.
Commissioner Hall, followed by Commissioner Harbert.
Mr. Pepe, are there existing buildings on this site that are going to be demolished?
There's one left. I think it was a La Madeleine. There's one left. Then, oh, you know what? There's 3 attached single family in the north corner. They understand are owned by the developer, and those would be demolished to build the development plan. Here's the other commercial building, and then there are 3 attached single family between the alley and Bowser Avenue that would be demolished in this case. But everything else on Lemon is already demolished a while back.
Okay. And I noticed looking through the brief that H-E-B, is this going to be an H-E-B store or what?
I'll be straight. It sounds like it's a no. I think they did own this site and they're moving it. They're moving on from it. That's my understanding. Because they're not the applicant developer, they're the landowner. Mm-hmm.
It was
Commissioner Herbert, please.
thank you. A point of clarification, you mentioned, and this is for educational purposes, but you mentioned something about irrigation, and you spoke really fast, which you normally don't do. Mike, can you talk about what you mentioned in your presentation about irrigation?
Yeah, those are in the sustainability standards that are required for the project. This draft doesn't have it here. So I don't have the full language, but I understand that it's part of the sustainability standards. It relates to drip irrigation from air conditioner and rainwater collection. So I understand it's related to that. I don't have the new added language in front of me at this time, but
I can
it's a
answer that.
requirement for landscaping.
They're required to collect any condensation from HVAC systems that are 5 tons or more and do rainwater collection and reuse it as part of their landscaping. They also intend to meet, it's not LEED, it's one of the other standards, but the city attorney won't allow us to put that in. And so we have tried to capture some other sustainability standards within the ordinance that sort of dovetails into what they're intending to do on the site.
And in those sustainability standards, they're put into the PD, or is it case by case?
Well, there's some sustainability standards in the PD, but the city attorney's office won't let us reference standards like LEED in the PD. So even though a developer may choose to comply with a LEED standard, we can't require it in the PD.
Okay, thank you.
Thank you. Commissioner Hampton.
Thank you. I see we still have Mr. Irwin, so I was wondering if I could ask a follow-up question on the tree discussion. Could you speak to the relative size variance? I think I understand the planting constraints and that a younger tree will adapt more quickly, therefore grow more quickly on the smaller versus the larger caliper. And I'm just going to say 4 to 6, keep it simpler on my mind. What would be the relative impact of that in terms of planting, in terms of scale of that tree when they were planted? Is that a significant height difference? And again, is there any sort of rule of thumb on how those infill, the younger versus an older, more mature tree?
Well, the more mature tree will obviously be taller. Depends on the species, of course, and also looking at the spread of the canopy also depend on the species. The larger tree will be taller immediately. It will take time for it to begin to grow in height, and that meanwhile the younger tree would typically be growing faster and catch up to the height of the tree over a period of years. By the time we get 10 to 15 years, they're probably going to be caught up with each other, in comparison. It also depends on the soil conditions that we're planting in. So, if we have optimal planting conditions, the younger tree will typically be more rapidly growing, but your mature tree, if it's being well maintained, will do well, and it's going to fill in the space immediately, and it'll look like it's been a more mature tree's been there for a while.
Thank you for that clarification. One follow-up, I noticed in the case report that it mentions the preservation of existing trees along Lemon Avenue. I didn't see those located on the development plan.
I don't think they're on Lemon. I think they're on Throckmorton.
Oh, Throckmorton, my apologies.
You got it, yeah.
I'm looking at the plan backwards, so my apologies. And so is there any additional, I guess, language that should be considered? And this may be a question for Mr. Pepe, but if the intent is to maintain those trees as a part of the overall landscaping, is there anything else that needed to be considered? And I'm confident Commissioner Kingston has this well in hand. I just didn't see it immediately.
Yeah, well, the language that's proposed is the number of trees required in the tree planting zone along Throckmorton is 8, which would be about the standard in the normal, so provided the 4 large live oaks existing prior to 2020 are shown in the landscape plan preserved. So otherwise, they have to meet the base standard. So their incentive to do it is they can plant less, they can preserve it, but that language, it's my understanding of, maybe I won't let Phil follow up if necessary, but my understanding it can be tricky to say it's absolutely required that this is preserved because of the health of things over time. We have to have an alternative, but the incentive there is they don't have to plant as many on that frontage.
Understood. So that's, and again, I was reading that and didn't quite understand the full context of it, so thank you for that.
Page 26. Mhm.
Yeah, thank you. So then a secondary question regarding the exceptions that are allowed related, well, two follow-ups. One, the exceptions on the screening, and I was noticing specifically in terms of the loading that is required. Is that a base requirement of PD 193? I see it reflected on the plan, but there's no standard. So is that deferring back to PD 193?
The loading, are you talking about the loading standard?
Correct.
On page 23 of the report with the conditions?
Yes.
So the loading standards were volunteered by the applicant specifically, and as I assume, as follow-up to conversations with the community.
Okay, I know we'll hear this individually, so I can ask them to confirm that. And then final question on the transparency requirements. I noticed it's much higher where we've got the GR zones. Is there transparency that is anticipated for the residential portion of the site?
Yes, so we have 2 layers of transparency requirements here. So they have to meet 40% minimum on Lemon, and then it's the 4.1107 transparency standards on every other frontage. And that one works a little bit differently. It's not a percentage, but it does. I think it's robust language. It talks about at least one window and one primary entrance at the street level, and then it says a transparent surface is required for every 25 linear feet of street fronting and open space fronting facade. So it's every 25 feet they require a transparent surface. So it's a different mechanism for transparency than is the 40% on Lemon. So they're going to overlap on Lemon, and I presume that if you're meeting 40%, it's easy to meet your 25%, or every 25 feet you must have an opening. But that's the standard that we use for mixed income projects, transparency, the one in 4.1107. Well, we have those for the residential portion in the back.
Understood. And then that is what also triggers any ground level units connect to the public right of way and all the other provisions that are included.
Yep.
Okay, thank you.
The parking screening, pedestrian scale lighting, yeah.
Thank you, Mr. Pepe. Thank you, Mr. Chair.
Thank you. Commissioner Carpenter.
Yes, Mr. Pepe, my question is about sidewalks, because I see that the applicant and staff are in agreement on the recommendations for the width of the sidewalk and the width of the parkway on Lemon and Throckmorton and Reagan south of the driveway. But can you explain what the difference is in the recommendation staff and what the applicant is offering on Bowser and Throckmorton? Because it doesn't seem to be just width, because the applicant's suggesting 4 and 10, which is 14 feet, and the staff is 6 and 5, so it's 11 feet. So is it trees or community preference, or do you have an explanation?
I understand it's community preference why they've volunteered 4. Staff acknowledges that, but staff recommendation is 6. The ADA passing distance for 2 wheelchairs is 5, so that's a floor you would see from me in terms of recommendation. They also have they have a 15-foot front setback on Bowser, for example. I see no issue in accommodating a certain amount of parkway and a certain amount of sidewalk nonetheless.
Thank you.
Thank you. Any other questions, commissioners, on this item? Thank you very much, Mr. Pepe. We'll go to 7 and 8. Let the record reflect that Vice Chair Rubin has a conflict on item number 7 and has stepped out of the chamber.
This is Z234-101. And this is an application for a specific use permit for an alcoholic beverage establishment limited to a bar, lounge, or tavern, and a commercial amusement inside limited to a dance hall on property zone FWMU3-SH Walkable Urban Mixed-Use Form Subdistrict with a shopfront overlay within Planned Development District 595, which is the South Dallas Fair Park Special Purpose District. Outlined in blue is the area of request on the area map. This is the zoning map you will see is surrounded by undeveloped Forest Park, auto service centers, vehicle sale, and manufacturing. The area of request is located at 2910 Botham Jean Boulevard. The structure was built in 1939 and is approximately 2,688 square feet. The only use authorized by this specific permit will be a bar, lounge, or tavern, and the proposed bar, lounge, or tavern will operate Monday through Friday from 8 a.m. to 1 a.m. and the next day, and Sunday 11 a.m. to 11 p.m. The next few slides will be pictures of the site and the surrounding areas. This is the site plan. On the screen now will be the conditions. And staff recommends approval for a 5-year period with eligibility for automatic renewal for an additional 5-year period, and it'll be subject to site plan and staff recommended conditions.
Thank you very much. Questions, commissioners? Commissioner Wheeler, please. Good morning.
Is there any reason the recommendation is for a 5-year and with the automatic renewal when this is a new SUP and the community needs time to adapt to it?
Can you repeat that for me? I didn't quite hear you. All I heard was the SUP renewal.
Is there a reason why the recommendation is for a 5-year period with an automatic renewal when this is a new alcoholic establishment in the community and the community needs time to adapt and see what would this business be an asset to the community?
Well, I spoke with Ryan about that, and he said right now we don't have a policy stated that all new SUPs shouldn't have automatic renewals. So that's why I left it as the 5-year with automatic renewals.
Okay. Well, let me rephrase that. Let me stop. So I know that it's not a policy, but putting a new SUP on is putting a new SUP on an automatic renewal. How does that give the community if they do something and it's automatic renewal and then it doesn't give the community room. It doesn't give the community room to have a choice on whether they want to keep them in a later date. If they renew their automatic renewal and at that time everything is okay, then the community is kind of left with something that they might not want.
Good morning, Commissioner Wheeler. I'll jump in on that. Yeah, so this is just staff's recommendation. As Gianna said, we are recommending an initial 5-year period with that eligibility for auto renewal for additional 5-year periods. Also, as Gianna said, although various commissioners, various communities may have sort of established internal policies on when they feel comfortable approving something with automatic renewal or not, city staff does not have a hard and fast rule or policy on when we recommend auto renewal or not. It's really just a case-by-case basis. In this case, we are recommending eligibility for auto renewal. However, you as the commissioner and your fellow commissioners, you're under no obligation to follow staff's recommendation if you weren't comfortable recommending approval of auto renewal to City Council.
Thank you for the clarification. Commissioner Herbert.
For further clarification, therefore, myself and newer commissioners, what goes in the decision from staff's recommendations on years of eligibility for automatic renewals? What goes in that decision making?
Yeah, I mean, like I said, it's really just a case-by-case basis. we don't really have any like formal guidance.
In this case, do you know why we chose this? Or is
I'll
it-
pass that to the case planner.
I chose to go with the 5-year with automatic renewal because I did not receive any opposition from the community. I didn't receive anything from the community. And then also I did it based on the use. So had I heard anything negative from the community, then maybe I would not have selected to do the automatic renewal, but I didn't hear anything from the community.
Perfect. Thank you. Thank you. That's what I wanted to hear. Thank you.
Yes, sir.
Thank you. Commissioner Carpenter.
Hello, we addressed this a little bit in an email, but to get it on the record at the briefing. This is a brand-new operator and a brand-new SUP. This operator has not had an SUP at this location before.
You are correct.
Okay, so even though an SUP was required for this use, a certificate of occupancy was somehow issued in error for this use, that's correct?
Yes,
Okay.
ma'am. The CO was issued in error for this particular use.
Okay, and so these SUP conditions, these are brand-new conditions that the applicant submitted, is that correct?
Yes, ma'am.
There are several conditions here that don't seem to be applying to this sort of use. I mean, it references a private recreational facility, it says field lighting is not permitted, and then the hours of operation, which include no Saturday hours, are very unusual for a bar. Was there any discussion about these conditions with the applicant?
Yes, and some of these conditions I striked out because they did not pertain to this particular use. But I did discuss that with the applicant, and he said that these are the hours that he wanted to operate it.
And so did he also have an explanation for the references to field lighting and private recreational facility? It almost looks as if this set of conditions was adapted from another use and didn't quite get where it needed to be.
No, ma'am, he could have used an example and maybe forgot to swap out some wording or anything like that, but he will be here this afternoon. That way you can ask him those questions.
Thank you, I appreciate it.
Yes, ma'am.
Questions, Commissioners? Commissioner Forsyth.
Is the existing, you say this is a new operator, the building that's there, is it currently being operated as a nightclub or as a lounge?
I believe so because they were issued a CO in error, so that's why they're here to get the SUP so that they can legally operate.
Explain to me that as the CO was issued in error. Help me to understand what that means. What happened here?
So whenever they went to the permit center to get a CO for this particular business, they actually got the CO for the business that's located next door instead of this particular address. So they was operating off of a CO that did not belong to this particular address.
How long have they been operating?
I'll have to check the system and see how long they have been operating.
We can have that this afternoon.
Insight to that. I can get some insight to that question. They actually was issued a CO on July 11th. The neighboring business called and contacted me. Their SUP for the neighboring business, some kind of way, development services attached to that business, but they had said that they needed a SUP. Also, they had went to the Board of Adjustments and stated that the building was not non-conforming, and the Board of Adjustment allowed for them to go back up under the previous use of PD 595 for the area, and then it triggered a SUP. They were, we went to Development Services, and Development Services put their CO on hold, but said that they didn't have to close, but they did have to apply for a SUP. They started this process in July, and they just gave the plans to the planner, the completed plans last week. Also, that particular operator is not telling the truth. They are open Monday through Sunday through Saturday. Saturday is the day that they're really open. So they're open 7 days a week.
Any other questions, Commissioners? Okay, thank you very much. The record will reflect that Vice Chair Rubin will be stepping back in shortly. Takes us to case number 8.
Item number 8 is KZ 223268. The request is an application for 1A new subdistrict for FWMU 5 walkable urban mixed-use form district uses on property zoned a DA duplex subdistrict, a CC community commercial subdistrict, and a PA parking subdistrict within planned development district number 595, the South Dallas Fair Park Special Purpose District. Number 2 is a specific use permit for commercial parking lot or garage on property zoned a CC subdistrict and a DA subdistrict within PD number 595, and 3, a specific use permit for a commercial parking lot or garage on property zoned a CC subdistrict within PD number 595, is generally located along the southwest line of South Central Expressway, northwest of Pennsylvania Avenue, and east of Julius Steps Freeway, approximately 7.88 acres. This is the location map. This is the aerial map. The area of request is the highlighted in blue. The zoning map, so towards the north is an R7.5A subdistrict and a CC subdistrict within PD 595. To the north is an R5A subdistrict and a CC subdistrict within PD 595. Towards the southeast is a DA subdistrict within PD 595. Towards the northwest is an FWMU3 subdistrict within PD 595. And then towards the southwest is PD 597. Surrounded uses. Towards the northwest is a personal service, single-family, undeveloped general merchandise or food store greater than 3,500 square feet use. There's also a fire station. And then towards the towards the southeast is single-family, and then towards the southwest is school. Towards the southwest is also an office building, general merchandise or food store less than 3,000 square feet, and then also undeveloped land. And then towards the northwest, there's a church, undeveloped land, single family, multifamily, and child care facility. And this is a zoomed in of the actual area of request. So the area of request consists of CC towards across Martin Luther King, and then between Martin Luther King and Harwood, it's that side itself is two zonings, which is a CC and a PA district, and then across is also a CC and a DA district. So the area of request, which is item number 1, is the whole entire side that is in red, so the whole entire square, which is sub-area A and sub-area B. A new subdistrict for an FWMU5, walkable urban mixed use. So they are proposing to redevelop the site with a performing arts center as defined in the proposed PD conditions. And then item number 2 is the area circled in green. It's an SUP for commercial parking lot or garage to facilitate the renovations of the Forest Theater. So that side, item number 2 is on the southwest line of South Central Expressway between Pennsylvania and Peabody Avenue. And then item number 3 is the area circled in blue, which is an SUP for commercial parking lot or garage on the north and west of the convenience store to facilitate the renovation of the Forest Theater. So that side is between, it's on the west corner of South Central Expressway and Martin Luther King Jr. Boulevard. So item number 2, both item number 2 and item number 3 are in sub-area B, but item number 2 is track 2 and track 3, and item number 3 is track 1. And then, so the sub-area A is the site with the performing arts as defined in the proposed PD condition. Performing Arts Center is a use that operates as a theater, community service center, alcoholic beverage establishment, public or private school, commercial amusement inside, restaurant without a drive-in or drive-through service, and an office as those uses are defined in Article 4 of Chapter 51A of the Dallas Development Code. And then this is the site plan for the SUP number 1, which is along Peabody and Pennsylvania Avenue, which is, as mentioned, the area in green. And then item number 2 is the SUP for the site plan for the SUP number 2, which is the area in blue. That area does have on that corner of South Freeway and Martin Luther King, there is a convenience store. Currently, they are not proposing to demolish that building there, so that is going to be out. So the other 2 areas towards the north and the west, that is the area they're proposing to do the parking. And then, so form district, form-based zoning differs from a traditional zoning. So in that, the zoning standards for traditional focus primarily on the form district focuses primarily on the form of the building, and the traditional zoning focuses more on the intended land use. So the desired form of buildings is typically more urban in style, characterized by multiple stories at front of site, closer to street, and then it combines the standards or street frontage, transparency, building articulation, and pedestrian amenities. And then it also is intended to ensure activity streetscape that encourages pedestrian activity and screen parking. It benefits the property owners, include additional building area, increased height, density, and floor area, and reduce parking requirements that encourage use of multimodal transportation. And form districts are intended for neighborhoods with dense urban character and high walkability. So this is an example of a traditional zoning district. It has its streets, if it's a corner lot or interior lot, it has its front yard setback, corner setback, rear setback, and side yard setbacks. And then sometimes it does have alleys are there. For an urban plan, and this is mostly basically on the development type that they are proposing, which is MU, mixed use. So the uses that tend to be for an MU, for the first floor is usually a civic, place of worship, office, retail, and service and entertainment. And then from the second floor to the upper floors, it tends to be for residential, civic, place of worship, office, service, and entertainment, and commerce. And then for the placement for a form district, it does base it on the primary streets and side streets. So for the side street, it tends to have a street frontage requirement of minimum 40%, front setback area minimum of 5 feet, and then maxed 15 feet. And then side setback does vary. For the primary streets, it does require street frontage to be minimum 90%, and then front setback area minimum 5, maximum 15, and then it does also have a parking setback. For the primary is 30 feet, and then for the side street is 5 feet. And then those can go more in detail, as I mentioned, sorry, hold on. So to see the variance between the base MU and what they are proposing, it can be in page 826 of the report. And then for the height, the building height does vary. It does have, for ground story height, a minimum of 15, 30 foot max, and then upper stories height are between, the requirement is 10 minimum and 15 feet max. And then for the elements, entrance spacing between the doors, primary street is 100 foot max. Then there's also a blank wall requirement. For primary street, the max is 20 feet. And then for ground story transparency, for primary is 50%, side street is 25%. And then for the upper transparency, primary streets are 20% and side streets are 20% as well. And then these are some character examples of an MU development type. And then these are the development types that they are proposing within the district. So a mixed-use shopfront, as I mentioned, a development type intended primarily for ground story retail and upper story residential or office use. And then they are also proposing an open space law development type for a portion of sub-area A. This development type is located and is designated to accommodate civic open space or natural area worthy of preservation. And then, so this is sub-area A. So the area in pink is what they're proposing to be the development mixed-use shopfront development type, and then the area in green, which is along Peabody, they're proposing open space lot development type. So these are some of the site photos of the site. On site looking north across Martin Luther King, then on site looking northeast, on site looking northeast, on Peabody looking northwest, on Peabody Avenue looking northwest, on Harwood Avenue looking northeast. And then on this one, I did go, it was a few months ago, however now Harwood Avenue, they actually made it into a dead end, so it doesn't go towards Martin Luther King anymore. And then on Peabody Avenue, looking southeast, on Peabody looking southwest, and I believe this building has been demolished or is no longer there. On Harwood Avenue, as well, that's the building, looking southeast, on Harwood looking northeast, looking northeast, looking south, looking southwest, looking southwest, on Harwood, looking northwest, looking north, surrounding uses, on site looking northwest, looking southwest, looking southwest, looking south, looking northwest, looking northeast, looking east, and then critical analysis. The area request is within the proximity of an existing form district to the immediate northwest and west of Julius Shepps Freeway, and over a 130-acre tract of WMU3 zoning exists adjacent to subject site directly to the west. And so the whole entire area in yellow is the existing district. And then within that area, there's an area in blue, which is along Martin Luther King, which is a shopfront development type. So the establishment of a WM district on the east side of Julius Shepps Freeway will create a neighborhood linkage with the redevelopment on the west side of the freeway and the rest of Martin Luther King Jr. corridor to the northeast. As we are aware, those freeways that were developed did break that linkage a couple years ago. So creating this new WMU district, which is the site of the Forest Theater, will connect the districts to the east and towards the west. And then, so the site is within the 360 plan. So the site is within the South Dallas Fair Park, which on the east of downtown. The proposal does meet the plan strategy to build complete neighborhoods, promote great placemaking, advance urban mobility. And then it is also within the Trinity River Corridor Comprehensive Land Use Plan. The site is located within the North Trinity Forest District, and the proposal meets the planned objectives to create a vibrant central city, enhance city's urban form to increase the appeal of urban life. And then it is also within the South Dallas Fair Park Economic Development Corridor Plan. The site is located within the Community Commercial Area Corridor, and the development meets the planned objectives of holistic strategy, improve basic attributes, which are the urban design, well-maintained buildings, and access to goods and services, and it encourages corridor reinvestment. And then staff consideration, staff does recommend the request to have residential uses, and it is a mixed-use form, and the mixed-use form are intended to accommodate a mix of compatible uses, which is residential and commercial. And then staff is recommending no minimum parking requirement as it contributes to generating pedestrian traffic and achieving urban design goals in walkable and transit reach areas. And it also creates a walkable urban neighborhood where higher density housing will promote less dependency on automobile. And staff's recommendation is one, approval of a new subdistrict for FWMU 5 subdistrict uses, subject to sub-area map exhibit and staff recommended conditions. Number 2, approval of a specific use permit for a commercial parking lot or garage for a 2-year period, subject to a site plan and conditions. And 3, approval of a specific use permit for a commercial parking lot or garage for a 2-year period, subject to a site plan.
Thank you very much. Questions, Commissioner Wheeler? Good morning.
Yes, was the updated were we including in this staff report the recommendations that the applicant was wanting, especially pertaining to the residential use? They updated that, yes, maybe Monday or Tuesday, that they, I have it.
Was the question if the staff report includes the applicant's request to prohibit residential uses?
Yes. They
Yes.
actually struck 2 different things off. They sent it to me Monday after conversation with you all. Let me make sure. I know staff there was two recommendations that they were against originally was the parking, minimum use of parking, from parking, and for the residential. But I believe that the parking, they understood that it was along with what the South Dallas PD 595 is moving toward, and I think they were okay with that, but they were not okay with the residential use, and they actually sent it to strike it out.
So, Commissioner Willard, these sound like they might be questions for the applicant at the hearing this afternoon, but the case report that was published in the docket last Friday, the applicant's request is to not allow residential uses and then also to require parking for these uses. If that has changed between when the docket was published and now, that could be incorporated into the motion. If a motion is made today.
So I think the parking they were okay once with the explanation was had on why that you all were moving, because they didn't want to offend the community on the parking. But once we talked to them about the reasoning for the parking at PD 595, area plan is asking for no minimum parking requirements in that area. But the residential, they did, we sent that over. We talked before we talked. And they sent over that to be striked out. They sent it to me, so I didn't know why they didn't send it to staff also. But
Yeah, we didn't receive anything. I'm not aware if the applicant did or not. The current proposal, as published in the docket, as Liliana just presented, is still to prohibit residential uses, and it's also to require parking for the use. If the commission wanted to today not follow staff's recommendation on the residential uses, but follow staff's recommendation on the no parking requirements, we can get Daniel to help you out with a motion to that effect.
Okay, I'm going to forward it to Yolanda so she can forward it to.
That would be good as well. Thank you.
Thank you. Also, and can you give me the reason that staff did not advised in this direction for a sub-district in PD 595 instead of a separate PD?
Yes, because so the SUPs, they are proposing to just have the commercial parking while the theater is in renovation, and then later on they are proposing to do new uses. Right now they don't know the land use, therefore we did recommend for them to all include it within the PD, which is actually the first sub-district within PD 595. So it'll be the first sub-district, but because they're including that, and they did mention that they are acquiring additional land that they will be including within this sub-district, that is the reason why we recommended for the SUPs to be within this sub-district.
No. Oh, it's not the sub-district. So I think your recommendation staff was to create a sub-district instead of a new PD. And what was that, and the reasoning for that?
Yes, because the theater is a big landmark for that community, and because it's already PD 595, we didn't want to take that landmark away from the PD 595.
Were you aware that the recommendation to them was to do a PD, and the reason that to do the PD is so that they can, because of the difficulties with PD 595 and the limitations, and because the community knew that they were acquiring more land, and this would allow for them, for us not to have to restrict residential at this time, that they could open up that PD back for a public hearing, and it include the other uses that they want, and to make it easier for them to work with us in the community?
Just as a functional clarification, I feel strongly that you'll have a very similar effect of having it as a sub-district versus having it as a full PD. You'll have a functionally similar effect if it comes to whether that's amending to put residential uses later, whether it's providing relief from the use or the any difficulties of PD 595. I do think that we've overcome any development difficulties of 595 with the way the text is written, and I feel strongly it's a PD, a different PD or an individual PD is a different approach, but I think we've overcome those difficulties, and you'll have a similar effect if you do come back to modify it or what have you.
So when this applicant comes back to modify, will they have to apply for different zoning per parcel, or will they be able, and then that would make them have to continue to modify their sub-district? And the reason I'm asking that is PD 595 is one of the most difficult PDs and knowing the area, the recommendation was for a new PD, which is not highly recommended. I definitely don't highly recommend them all the time, but it was because we knew, and their properties are continuing and they're kind of enclosed between two freeways. And it was them, they kind of sit alone in a way.
I gotcha. Yeah, well, to your first question, pretty straightforward. If they still own or have some sort of signature authority for the other parcels, it's really as simple as another rezoning to open it up, to amend the sub-district, to do whatever you need to if necessary, which would be basically the same case if it were an individual PD. Because it's singled out as a sub-district, they don't have to go parcel by parcel for any future rezoning. But I think that it is a balance of maintaining some of the established norms of not just the PD 595, but the neighborhood, but also obviously overcoming some of the development difficulties of PD 595. And I think that we've hopefully negated as many of those as we could in a thorough review of 595. So it remains there without creating a PD donut hole, but I think it resolves the difficulties they would face. And not only that, but kind of builds on a consistent connection to zoning south of 45, north of 45. I hope it can bridge that as best as it can in a regulatory sense.
Okay. And one more thing, will this sub-district allow for alcohol, any kind of alcohol use?
Yes, it would not prohibit that. So it could be in a restaurant or alcoholic beverage establishment is another use in the.
Yeah, so within the Performing Arts Center custom use that's being added to this sub-district, alcoholic beverage establishment is proposed to be permitted by right within sub-area A. Elsewhere in this proposed sub-district, give me 1 second.
Is that not, but by right, and the reason I'm asking that is that the community by right with restaurants are okay, but separate alcoholic beverage like beer and wine stores, liquor stores, is that they don't want that, but with the accessory use in a sense, they are okay with that.
Yeah,
So,
the only place where the use alcoholic beverage establishment would be permitted by right is within sub-area A. So the parcel where the Performing Arts Center use is. And then as far as the remainder of the sub-district, it would be, and there's a typo in the case report, I apologize about that. It would be permitted, but only by SUP and only on the ground story of any multi-story buildings.
Thank you.
Thank you.
And liquor store is not a subset of the Performing Arts Center use.
Questions, Commissioner Hampton?
Thank you, Mr. Chair. I think we heard some of the conversation that this is a iconic landmark for this community. Previously was considered for landmark designation. Can you speak to any discussion? I don't see anything in the conditions that responds to that and the role that the structure, that its tower have played. Is that something that was considered in these crafting this new subdistrict?
We talked, Mr. Baldwin is actually going to have, the applicant is going to have someone come to speak to that. They are not going for a city landmark because it will limit them to a museum, but they are going for a federal landmark. So they don't, so from my understanding, but they're going to have someone here that's going to speak to the reasoning that is the way it is.
And I will thank you, Commissioner Wheeler. I don't think that Mr. Baldwin will be surprised by my question either. Thank you very much.
I'm thinking that that's the reason. Yeah.
There are no surprises left. Commissioner Carpenter.
I have a question about the definition of performing arts center. It says it means a use that operates as a theater, community service center, alcohol, beverage establishment, public or private school, commercial amusement, inside restaurant without drive-through, and office, as those uses are defined, et cetera. Does that mean that this performing arts center has to have all of those uses to be considered a performing arts center, or can it include those uses?
The conjunction there at the end of all those uses is and rather than or. So as it's published in the docket, that is correct. They would need to have all of those uses in combination to meet that definition.
But is that the intention of the community, that it needs to be all of those things? Or
I think the intention, I don't know if it has to be all that, and maybe it should be or, but it is in an area that is now kind of our a performing arts district. The school, the DISD school is, we kind of consider it the baby Bishop Arts, no, what's the school? The Performance Arts School downtown, Booker T. Washington, so it's considered the baby Booker T. Washington. Also with St. Philip's is also, there's a black box, we approved a black box earlier for Martin Luther King, Dr. Martin Luther King Jr., I believe it's a magnet of sort. It's a performance art, so that whole district is kind of the performance art district of South Dallas. So I don't know if it needs to be and with the or, because it might not meet some of those, to give them a way out. So maybe the or needs to be included.
yeah, that may be a question for legal, because my question was, I mean, I think I understand the intention behind what the theater is supposed to be redeveloped as. I just didn't want it to get hung up on, you know, if all of those uses didn't happen to occur within that theater, you know, would they not qualify as a performing arts center?
Definitely, we should visit that, because I don't think the community looked at the and. They just knew that they was bringing that, so maybe that and or might, we definitely don't want them to get hooked up in the future, or development service to interpret something.
Yeah, and speaking from the staff side, I mean, we're in support of the use, however it is. I mean, this is an awesome project. It's just so much of this case has been logistics. With this particular definition, we actually looked to the representative, and they're experiencing getting C of Os with development services to sort of help us craft the language of that use. So that's why it is what it is. But yeah, if it needs to be edited or the conjunction changed or whatever, that's definitely something staff is supportive of.
And
so
if I can piggyback on that, my concern with changing that conjunction to an or is that I think it would allow an alcohol beverage establishment by itself, by right, And so I think if we're going to change the definition, it needs to clarify that it's a combination of these uses.
Well, I leave that to legal to sort out. I just have a question. I did have a question about sub-area B, where it says the following additional main uses are permitted in the sub-district, commercial parking lot or garage by SUP. But my understanding of the FWMU5 farm sub-district is that commercial parking lot or garage is already, that is part of it. It's allowed by SUP. Was there some reason for spelling that out?
Yeah, so Commissioner Willer kind of touched on this with one of her earlier questions. There's definitely a point to be made here about how the many overlapping layers of zoning regulations in Dallas can contribute to logistical problems like this. Trying to choose my words carefully.
So are we looking for absolute clarity?
Yes. So you know, we spent I think 10 pages of this 60-page case report explaining just what uses would be permitted in a sub-district like this in 595. So we did all that because we wanted to lay it all out there. But then beyond that, we wanted to hard code in the very specific uses specific to this project, how those would be permitted. As Commissioner Wheeler said, just in case there is varying interpretations at permitting.
All right, well, a follow-up question is, in the chart, when it was spelling out the difference between, you know, FWMU5 and the different sub-districts, under office and theater, it said by right in sub-district A only. But in base code FWMU5, office and theater are allowed by right. So if you're not wanting to allow office and theater by right in sub-district 2, then I think that probably needs to be added there.
Yeah, that is the typo I mentioned earlier. I noticed that yesterday at 4:30, reviewing this case report. I got a little fixated in my editing on the two different sub-areas. For office, because it is permitted by right in a straight FWMU5, it would also be permitted by right in both sub-areas A and B. It's only in sub-area A where we are hard coding it as being permitted by right because it is part of the Performing Arts Center custom definition. And the same for any of those other uses in that final use comparison chart where there are strike-throughs in the second and third column. That's definitely something we'll be correcting when and if this case goes to council.
Well, thank you. That's it for me.
Thank you. Questions, commissioners? Okay, thank you very much. Awesome job. We'll get some clarity on the wording for that, Mr. Moore, for the hearing. We'll get some clarity on the wording from you, sir.
Yes, I will work with the commissioner and we'll come up with something.
Thank you, sir. Is David here?
David, are you with us?
We'll keep going. We'll find him. We'll go to case number 9, commissioners. Mr. Bate, good morning, sir. Oh, there he is.
What was the question for David?
I believe there may be questions on this case for him, so we were just kind of adjusting for him. Thank you, sir.
On 9, okay, thank you.
Thank you.
Good morning, Commissioners. This is case Z223305. I'm Martin Bate. And I'll share the screen real quick. Excellent. All right. This is, please stop. This is an application for, 1, a planned development district for MU2 mixed-use district uses, and 2, the termination of deed restrictions as amended, Z72-269, on property zoned to GOA General Office District. It is located on the south line of LBJ Freeway between Noel Road and Montford Drive, and is approximately 8.6 acres in size. Here we see it in the northern part of Dallas. It's right there along 635, immediately south of the Galleria area, or as they now call it, the International District. Here's the aerial map showing the subject site. You see LBJ to the north. And here's a zoning map showing some of the surrounding uses. To the north is PD 887. That's part of that Galleria International District area. The subject site currently zoned GOA. It's developed with office buildings. They are vacant. When I went on my site visit, there were a smattering of cars there, presumably people taking phone calls of sorts. To the immediate south is an MF1A multifamily district that is developed with multifamily housing. And to the west is an MU3 mixed-use district that has a variety of uses. I believe the main thing is a hotel, but there was also sort of a kind of like a distribution center looking thing for some sort of courier service. And then to the east are both an MU2 mixed-use district and an MC1 mixed commercial, I believe it is, that had a variety of retail, personal service type uses. So as mentioned, it's currently developed with 3 office buildings and a parking garage. The offices are vacant. And the purpose of the request is to allow modified development standards primarily related to setbacks, density, floor area ratio, height, design standards, and mixed income housing to allow multifamily. The developer is proposing retrofitting the existing 10-story office building as multifamily, and then demolishing the 2 other buildings and replacing with additional multifamily housing. In order to accomplish this, they're requesting a PD with modified development standards, and the PD includes conditions to trigger the mixed income housing development bonus. With the site photos, we'll start to the western part of the site. This is on LBJ and Noel, looking northwest away from the site. And looking west from the site towards, again, I mentioned that sort of distribution center looking thing. It's not an actual DC, but it looks like a large warehouse, again, some sort of courier service. Then looking southeast towards the site, you can see the shorter of the 3 buildings in the foreground, well, in the 4 of the background. And then again, a little closer. Then going down Noel Road, looking east towards the site. And here's at the tail end or the bottom end of the site. You can see that the garage is there in the center of the photo. Then there's this sort of access driveway that goes into the garage, and then the multifamily to the south, or to the south, but it's on the right side of the photo. Here we are on LBJ Freeway looking north towards the International District. And looking northeast, again, in the right side of the photo, you can see the existing shorter building and the existing 10-story building. Looking southeast towards 2 of the buildings. Looking east. Looking west. Then looking southeast directly at that 10-story building that would be retrofitted. And then going over to the other side, looking at it from a different angle. Looking west. Looking south at this is the other shorter building that would also be demolished. Looking towards the east. On LBJ Freeway and Montford Drive, looking southwest. On LBJ and Montfort, looking north at the International District. Then to the northeast. And there to the right, you see some of those retail uses I mentioned. Looking to the south, the site's to our right in the photo. Looking southwest towards the site. Then going down Montfort, looking west directly at the site. Looking to the north on Montfort. Looking to the east, again, there's a variety of retail and personal services. And to the southeast. Then on site looking east, there's what appears to be multifamily as well. And then looking west, there you see this parking garage and the existing short building. And to the northwest. The proposed development plan, now what's in here is slightly out of date. We received a revision overnight that addressed some concerns that engineering and staff had regarding the development plan. I will share that with you now. All right, so it's a large development plan. We can just see it from a full zoomed out view here. But as we attempt to zoom in, cannot pinch to zoom. Doesn't quite have the Mac OS magic, I guess. So here we see the proposed building number 1 that would be in place of the existing short building to the west of the site. Then in the center, the existing 10-story building that would be retrofit. And to the right, proposed building number 2, again replacing the existing tall building. To the south, they would like to retain the existing 4-story parking garage. You see a large amount of open space that has been designated. They're proposing 65,000 square feet of open space, which is about 17% of the lot would be open space, which is above the 10% minimum that's required in a base MU2 district. Access to the garage would be via Montfort Drive and Noel with these 2 side driveways. And, pardon me, the point of contention that resulted in this last-minute change was originally they had envisioned having access from LBJ directly to the garage as well. Engineering raised concerns about this, primarily related to safety and engineering standards. With the amount of traffic that would be projected to flow out from the garage onto LBJ, it would create issues regarding either blocking this right turn lane, as well as safety from emerging traffic that is attempting to enter that right lane. They wouldn't have enough of a slowdown before that split, as well as cars exiting from here to reach the U-turn lane to get onto westbound LBJ. What the developer has proposed is to thus cut off the connection of that drive aisle, so it would not connect to the parking garage. They reran their numbers for their traffic impact analysis overnight and found that it would not have a substantial impact on the outflows on LBJ or on Montfort and Noel. As such, we are comfortable with this proposed plan here. Again, the big concern was that with having access to the garage, you'd have a lot more vehicles coming out at any given time or entering. And so this alleviates that concern. Let me just go back to this one. Now share this screen again. With the proposed conditions, so we are using an MU2 mixed-use district as the base zoning. We wanted to retain the GOA or General Office District FAR 4.0. The reason for that was to protect some of the existing entitlements that are allowed on that land. As we know, development isn't always a sure thing, and so if they were to back out, we would like to make sure that the existing uses would still be compliant. A maximum height of 182 feet, which was actually imposed by the existing deed restrictions, thus is the reason for the proposal to terminate the deed restrictions, as we call it. We don't want the belts and suspenders here. If we can remove a deed restriction but retain the spirit, then we can certainly do that through PD conditions. Modification to setbacks is 20-foot setback on LBJ and a 10-foot setback on Noel and Montfort. The maximum dwelling unit density that would be allowed, this is a deviation from MU2, is 50 dwelling units per acre. The mixed income housing development bonus would allow 90 dwelling units per acre, which is around what MU2 can permit with certain mixes of uses. The intent here is that from the outset, the developer was interested in providing mixed income housing and providing about 725 dwelling units, as I recall. So the 90 dwelling unit per acre density would allow for that if they provide mixed income housing. And the target proposed is a minimum of 5% units at 81 to 100% of area median family income. This is because of guidance that we have from the housing folks where given the MVA area, the market value analysis area, the area that it's in is classified as an IMVA area. And so our policy is to encourage in these lower market value areas to have the tranche, as it were, of the mixed income housing target be at the higher end to allow for that, again, that mixing of incomes, as it were. We don't want to concentrate lower incomes and lower incomes. That has not worked in the past. It's, created issues, and so we want to have that mixing of incomes. If it were a higher income MVA, we would propose a lower tranche. Here's a comparison of the development standards. It might be a little hard to read, but I will zoom in here. So with the existing GOA, there's a 15-foot front setback and an additional 20 feet for the portion of the structure over 45 feet in height, and then 20-foot side and rear setbacks when adjacent to residential and no minimum in all other cases, and then a tower spacing requirement. no minimum lot size or max dwelling unit density, which makes sense. It's intended for offices primarily. The FAR is 4.0, and the height is actually 270 feet, but the existing deed restrictions do limit that with 80% max lot coverage. Whoa, did not want you to do that. Let's attempt this again. Here we go. With the base MU2 district, the front setback is 15 feet, an additional 20 feet for a portion of the structure over 45 feet in height. So what's being proposed here is that you would have 20 feet along LBJ and 10 feet along Noel and Montfort, which would be in line with the 10-foot setback, maybe a 20-foot setback normally on LBJ or on Noel and Montfort, but in this case it would be 10 feet. We would not require the tower spacing for the existing parking structure, and no urban form setback required for the new developments. There's no minimum lot size in MU2. There's a 50 dwelling unit per acre minimum with no mixed use project. 75 dwelling units with a mix of 2 categories and 100 with a mix of 3 or more. In this case, given the intentions of the developer and what we want to accomplish here, we're proposing a 50 dwelling unit per acre base, which would be in line with MU2, and then the 90 dwelling unit per acre bonus with mixed income housing. The FAR would change as well to 4.0. MU2 normally has a lower FAR, but in terms of the impact of what could actually be developed here, you would actually have this height limit here of 182 feet, so it would sort of minimize some of what could come out of normally a larger FAR, and then retaining the same maximum lot coverage. Zoom back out to normal dimensions, and so staff recommendation is approval, subject to a revised development plan and conditions as briefed, and 2, the approval of the termination of deed restrictions as amended, Z72-269, as volunteered by the applicant.
Thank you very much. Commissioner Hellstrom.
Yes, Mr. Bate. So I was trying to listen on the deed restriction and the height situation, but I need you to walk me back through that. Sure. Why the base zoning currently is at 240, we've got a freeway site, and we're removing height. Help me understand that.
Sure. So the existing zoning does allow for 270 feet of maximum height. However, my understanding is whenever this was first developed, deed restrictions were volunteered. I can't speak to the intent behind that, but the deed restrictions are somewhat labyrinthine because as they were originally written, it only accounted for it only accounted for a shorter building. When it was amended, it allowed for a taller building up to, I believe it was 186.5 feet, and it would allow for, I think it was 186.5 feet and 14 stories, and then an additional shorter building. Those remained in place for several decades, and they seem a little superfluous now, given that we do have this opportunity to write a PD. The developer's intended max height for the buildings would just be this 10-story building, and so we thought it would be appropriate, given that these deed restrictions did exist previously, that we could retain that maximum height of 182 feet by putting it into the PD conditions. So therefore, by having that maximum height, you retain some of those protections of the deed restrictions, but you get the opportunity to remove them. Again, we try to avoid having these not necessarily conflicting, but just additional conditions that, for instance, at the time of permitting, it would make it a little more difficult for development services staff to look at what exactly controls here. Does that answer your question?
I suppose so, but,
I think maybe the question is more, why are we restricting height to what the deed restrictions
we've got a
currently
site
restricted
here,
to?
we're going to pick up housing units, and we've got a very low base density, and we're taking height away from the site. Now, I don't understand, maybe the applicant's perfectly happy with that, but,
sure.
This is a case where I would entitle it beyond what the applicant is asking for, because we don't know how quickly the applicant would build this project, this is a perfect opportunity. There's a lot to like about this case, but even the 182 is, by my estimation, not being used by this project. I don't think that existing buildings, I think it's more like 150. And so, I don't know how we got to 182. So anyway, I can save this for the applicant in the afternoon, I suppose.
Certainly.
And I guess I I love the open space around the buildings on the ground floor. I guess this body's not going to be, is not worried about fire lanes and whether or not, because I don't see how it works, but I'm just not going to worry about that, I guess.
We did not receive any objections from the fire department from their review at ZRT, the zoning review team. I can't speak any more on that in terms of that, but we did not receive any objections from fire, no.
Okay. All right, well, I guess that's all my questions for this morning on it, but thanks.
Thank you.
Thank you. Commissioner Sleeper.
I have a sort of a follow-up question to one that was just asked. I have a little bit of a unique perspective on this because I developed this building back in the 1980s.
All right.
And I'm quite sure that the deed restriction on the height restriction was not something that we volunteered. It was something that for some reason at that time the city thought they wanted to limit the height. And if you think about it and you look at that area, it's right next door to Lincoln Center, which has buildings that are quite a bit taller than this. I can't see how that height limitation today, I don't know if it made sense back then, but I can't see how that height limitation today makes any sense. And I can pretty much assure you that there's no sentimentality among the previous owners to maintain that height restriction. So if it's not inappropriate to do so and the developer doesn't wish to maintain that height restriction, I agree with Commissioner Housewright that it would make a lot of sense to lift that deed restriction. And just do I understand correctly that the owner intends to demolish the two, they're 6-story buildings and redevelop them as multifamily? Is that correct?
That is correct. They would demolish.
And then the center building would be converted to multifamily?
Correct. They would be able to provide more details on that from an engineering perspective, but as I understood it in our initial conversation, it had something to do with the floor plates of the 10-story building being more appropriate. I'm certain they can elaborate on it. I'm not quite as well versed in engineering myself, but as I understood it, the bones of the 10-story building work well for multifamily. The bones of the 6-story, not so much.
Well, it's an interesting statement on the state of the market in Dallas, Texas right now to think that somebody would be making that kind of conversion. Thank you.
Times are good. Commissioner Carpenter.
My question is about traffic, and I know you ran through it, but I didn't catch the implications of what you said, the change that had been made to the development plan, because there was a traffic impact analysis done, right? But we didn't receive it? Is that?
The TIA, I'm not sure if you received it. It might not have been included in the docket.
Yeah, I didn't see it in the docket, but it didn't look to me that there was a solution on the development plan that we got. And I know so from what you were saying just a few minutes ago, the driveway is going to stay the same, the location, but what changed that made it more acceptable?
What changed? So the original development plan that was included in the briefing, or not in the briefing, but in the docket and the report, it showed the driveway accessing the garage, which is not the case today. Right now, the driveway terminates at the parking lot, and I think one of the buildings is in the way. Staff's recommendation was to not allow access to the garage or even to eliminate the driveway. With the revised development plan that I briefed and presented on the screen just now, the developer has decided to go with staff's recommendation of not having access to the driveway, not having access to the garage from LBJ. As such, it would only access a small parking area with, I believe, 18 parking spaces, which could theoretically be used for deliveries, drop-offs, that sort of nature.
And so that modification would satisfy TxDOT's problems with the drive and also the problem of people trying to do the 5-lane changeover to get to the U-turn at Montfort?
It would. Technically, you could still do that, but the amount of traffic attempting it at any given time of day would be substantially less than if it had access to the garage.
Okay, thank you. My other question is about open space, because the staff report says that a minimum of 65,000 square feet of open space defined in PD conditions is required. But when I get down to PD conditions, it just says 65,000 square feet of open space is required. And I know 11 whatever it is, the mixed income housing design standards, say that open space, can be up in the sky, on rooftops, wherever. I mean, is the intention for it to be, it doesn't say anything about contiguous open space either. Is the intention here to be 65,000 square feet of ground level open space with some big portion of it being contiguous? Because it seems pretty undefined in the standards in the PD.
So regarding that, the 65,000 square feet, as I understand it, is all ground level. Could you remind me the first section where open space was?
In your report?
Yes.
It's on page 9-12.
9-12.
Yeah, under design standards. It says it follows the provisions of 4.1107 with the following changes.
Thank you.
Yes.
Define and PD conditions. Thank you. So that might have been a typo or a mistype. Originally, they had defined open space differently under the PD conditions in section 103. When we reviewed that, we made an update to it that removed that definition to instead use the normal definition that's used in the city code for 1107. So whatever control is there is what we control here. I can pull that up if you'd like to get the exact language.
That's okay. But the way the PD is written now, they would have to have 65,000 square feet of open space, but it would not have to be, none of it would have to be at ground level. Is that correct? Because 4.1107 allows it to be in the sky or wherever, or if there's an intention for there to be an amount of contiguous open space at ground level, then the PD needs to say so, because any development plan that comes forward in the future only has to comply with the PD. Is that correct?
Yeah, so if you look at 114C, the top of that section does say except as provided below, everything needs to meet codified mixed income housing design standards. So the only modification as far as open space is that it's about 17% of the site now rather than 10%, which is what 41107 would require. But other than that, as this reads, and Daniel can check me if he needs to, but other than requiring more open space, all of the standard requirements for open space as far as where it can be located and everything would just comply with 41107.
But my point was that if the intention for this project is that some ground level open space is required or contiguous open space is required, then the PD would need to be modified to say that.
Right, yeah, I don't, in my mind, don't have the exact open space standards from 41107, but yeah, if those are not codified, then if that's desired, they would need to be added as conditions to the PD.
Thank you.
Thank
Yes, and I am attempting to pull up those conditions, but the internet is being rather uncooperative this morning. But I can get that definition to you after.
I read them last night, and I didn't see anything that would require ground level contiguous, but.
Got it. Thank you.
Thank you.
Commissioner Hall.
Yeah, just a bit of clarification. The 10-story building that's being kept is 145 feet tall at present. And the other two buildings that are being demolished are going to be replaced with only six-story wood frame buildings. So they really aren't planning on building up to 182 feet or any higher.
And it should be worth noting as well, with the base MU2 district, the max height is only 135 feet, and so it would make the 10-story building non-complying. It does provide a 180-foot bonus if you have what's considered a mixed-use project in the code with retail. However, given that the plan does not currently call for retail, that would still be too restrictive. So that was another reason for modifying from the base height, but certainly no objection to increasing that max height.
Commissioner Forsythe.
In your pictures, I noticed that there were some mature trees on the property, on the site. Are they being maintained, or are they going to be demolished? Is there a landscape plan? I didn't see that.
A landscape plan was not submitted with this. They would need to comply with the standards of Article 10, which is the city's general landscaping requirements. As I understand that does require either preservation or replacement of trees that would be demolished, but I don't have details on how that would look with the final development.
Second round, Commissioner Housewright.
Mr. Bate, the proposal is for a 4.0 FAR?
Sorry, one more?
The proposal here is, the recommendation is a 4.0 FAR?
Yes, we put in the 4.0 FAR just as a way to sort of retain some of the existing entitlements from the GOA zoning. Again, given that the site, if for whatever reason it were not redeveloped, we would like to still retain that. I don't know off the top of my head whether the existing buildings have an FAR greater than the 1.9 that would be allowed by an MU2 district. But we wanted to keep that in there as a method of sort of retaining those entitlements there.
Well, I'm just trying to align FAR and height and unit count and all this. And by my estimation, the project as proposed is going to be around a 2 FAR. And so we've got 4. But why do we even have to limit the units? If we say, if we're going to have a height limit and an FAR, why do we even have to talk about units?
So with the units, one of the things would be that it was a way to ensure this mixed income housing bonus could be triggered by allowing it to be in excess of a baseline of 50. That essentially gives an incentive for the mixed income housing to be used. As a bit of background, when the proposal first came in, the conditions were such that the mixed income housing development bonus would allow multifamily use on the site. That's not something that we can really do with mixed income housing bonuses. We can't provide extra uses. And it's sort of putting the cart before the horse in a way of saying, oh, well, if you say you'll do this much mixed income housing, then you can build multifamily. So instead, what we looked at was an approach of using the dwelling unit per acre as the incentive, as it were. So if they did not provide mixed income housing, they wouldn't be able to build what they're proposing. Certainly there's, I think, to use a Turner phrase, there's many ways to skin a cat with it. We just thought that dwelling units per acre would be appropriate, given what was presented to us.
Well, but we could get to mixed income housing with FAR bonuses or height bonuses.
Yes, that would be another way of providing the mixed income housing bonus through FAR, additional FAR entitlement or height entitlement. Yes.
Yeah.
Commissioner Sleeper.
You may have just answered this, but I don't think I heard it right if you did. So the developer is basically voluntarily downzoning the property and converting the use from office to multifamily. And why does that trigger a low-income housing requirement?
So in terms of whether it's downzoning or not, it really is. It's more of I would call almost like a lateral change in the zoning. As it is today with the GOA, if you took away the deed restrictions, all that you would really be able to do is just build a taller office building. By switching it over to MU2, you're allowing different uses that, in this case, one of the main one is multifamily. We found that would be most appropriate for what's being proposed. It would also still allow office uses. Again, if this were to if for whatever reason the development did not come to fruition, it would still allow this use to exist, whereas the straight multifamily district would not allow that. And the second part of the question, with the mixed income housing. In terms of triggering it, really what it is that the developer I think their intention is they want to provide mixed income housing and they want to work with the city to, I guess, have that codified in here. And so by having the development as presented with 725 dwelling units, you need about a 90 dwelling unit per acre density in order to achieve that. So if they don't provide the mixed income housing, then the development as proposed simply, it wouldn't be able to be as dense. They could have much larger dwelling units. They could maybe not build one of the new towers, or maybe not build both of them, but it would need to have that, it would need to comply with that 50 dwelling unit per acre minimum. So in terms of using that as the sweetener, again, the idea is if you provide mixed income housing, that 5% at 81 to 100% AMFI, then they'll be able to build as envisioned. Otherwise, they have to go back to the drawing board.
So maybe I just missed this. What is the height on the 2 buildings that they're tearing down and replacing, where they're building new buildings?
The new buildings would be 95 feet max. And that's interesting with the 145 feet that Commissioner Hall mentioned here on their development plan. It says 182 max building height for the existing building. But that's the highest that it could go, would be
But
182.
the new buildings are not taller.
No, they would be shorter. They would be shorter than the 10-story building. I believe they would be.
Right, but that's already there.
Yeah.
So they're not upzoning at all, and they're only being required to do affordable housing because they want to. They're doing it voluntarily, not because there would be any zoning ordinance that would require it. Is that correct?
So if we're moving to from a GOA to an MU2, that allows the residential uses, of course, and then an MU2 without any sort of mixed use project, which is what they're proposing, a non-mixed use project. It's really just residential at this point. The max dwelling unit density they could have in MU2 is 50 dwelling units per acre. With the PD, they're proposing that 50 dwelling units per acre as their base, and then incentivizing the affordable units by saying that they can go up to 85 dwelling units per acre if they provide affordable housing. So that would be more than the base district because they're not proposing a mixed use project. Does that make sense?
Could they not have just proposed it all as a multifamily project as opposed to a mixed-use project?
They could do that as well. To get that dwelling unit density, they'd probably be looking like an MF3 or an MU3. Those are of course, the denser MF and MU districts we have in the city. Rather than that, they went with an MU2. I don't know if that was more of a comfortability factor with the surrounding community or not, but under a straight MU2, they couldn't get that density without a bonus.
But at the end of the day, they're building lower density than what they have now, and yet it triggers an affordable housing requirement?
Well, when you say right now, do you mean the existing GOA?
And what's there right now?
Right, yeah. So the existing zoning doesn't allow dwelling unit density at all. It doesn't allow dwelling units.
I understand. And I'm just talking about the building density that's there now versus the building density that's going to be there.
Gotcha.
They're not increasing the density.
When you say density, do you mean more the height, the FAR?
The volume of
massing?
the volume of the building.
Okay, yeah. Yeah, so that is, as Martin said, kind of a down zoning from what's permitted today. But under the existing zoning, aside from the massing of structures and stuff like that, the existing zoning doesn't allow residential units. So because that's what they want to allow with their proposal, suddenly we have to consider dwelling unit density in the mix as well, not just the massing and the height of buildings. We're looking at units for people now rather than offices.
Maybe I'm just missing the concept here, but generally I thought affordable housing requirements were triggered when you are asking for an increase in zoning rights. This is not really an increase in zoning rights. It's a change from office to mixed use, and yet in the eyes of, unless for some reason this developer just wanted to do, I don't know why it would trigger a requirement, but you're saying it triggers a requirement to add affordable units, even though they're not increasing the density.
Yeah. So the thing that incentivizes the affordable units is not just development rights in general. This is kind of where I want to differentiate between development standards and permitted uses. So what you're focused on is the development standards, the height, the FAR, et cetera. But the way for this multifamily project to work is we don't just have to look at development standards, the zoning rights, we also have to look at the permitted uses. So although they are, you could say they're losing out in terms of what development standards they'll now be entitled to, they are gaining the uses that are permitted now, the residential uses, which they don't currently have today. So I think that's the trade-off, if that makes sense.
Thank you. I hear what you're saying. I don't really get it, but I hear what you're saying.
Okay.
Thank you.
Commissioner Rubin. Commissioner Kingston.
I'm just going to join in the band that questions why we're limiting height at this location.
Yeah, that kind of goes to the same point. It's a decrease in development standards, but they're gaining that permitted use that they don't currently have today.
Commissioner Rubin.
So theoretically, if someone wanted to alter the PD ordinance to modify or eliminate that height limitation and go to just whatever the base MU2 district for the PD allows, is that just striking a single line in the ordinance, or what would the mechanism for doing that be?
Well, my only concern with striking that out and using the base is that the base MU2 only allows a 135-foot height as a base. Now, there's a sweetener in there if you provide, again, what's called the mixed-use project with retail. So if they built a building that had multifamily and then put retail at the bottom, it could go up to 180 feet, which that could be done with the 10-story building, for instance. But if you were to just have that base height, so if they developed it as envisioned, that 10-story tower would no longer be in compliance because it's taller than 135. So you need to have you need to modify from base MU2 regardless in order to allow that existing 10-story building. But it could certainly go higher.
Okay, thank you.
Yeah, and we're getting I really like the questions we're getting today. I think it's good discussion. They're sort of disruptive. I mean that in a good way. One thing the commission could do, rather than this PD for MU2, is I don't know if a straight MU3 district would work. I think we'd have to look at that and run the numbers and make sure that there's nothing we're missing. Please, yeah.
You'd lose open space.
Yeah. So it's everything is sort of we'd have to look at what that mix is. But there is the concern about the height. Max height in MU3 is the same as the current GOA. FAR gets you to a 4.0 max, just like GOA does. So yeah, maybe a straight MU3 or a PD with an MU3 base that we modify off of to get better open space standards or whatever else is desired. Maybe that's a good way to go. And I appreciate the questions, I really do.
Any other questions, commissioners? Okay, let's go back to case number 2. Commissioner Kingston, we're briefing these as needed. The minor amendment, we held off on that one. Would you like it brief?
Briefed.
Thank you very much. Commissioners, let's go ahead and take a break before we get to our Forward Dallas piece. It's 11:18. Let's be back at 11:30.
Thank you all so much. 1 second. All right, today's going to be a continued discussion from our last workshop item where we're looking at the place type map and suggested changes. So what we're going to do is continue the discussion on that, just to kind of bring everybody up to speed in terms of what we've done so far. We've had our workshop March 28th, and we talked about the place type descriptions and a few place type map suggested changes. We're going to continue the map component of our discussion today. What we would like to do is publish an updated map for the public to see based on the feedback that you all have provided us, so they have enough time to provide some comments when we get into the public hearing in a few weeks. So what we're going to do is talk through some of the place type map change suggestions, some issue areas that we'd like to confirm and clarify with you all. And then moving forward, as we look to the next workshop that we are going to have with you all, where we talk about the implementation plan and other plan document sections, we're also going to continue the place type description review with the community residential in that workshop. So this particular slide shows what we talked about so far. So within the place type description section, wherever you see a green check, that's where we've received input from you all. Wherever there is an orange check, there's ongoing discussion just to clarify direction on that. And then wherever there's just a blank box where you have to have that discussion with you all. So today, we're going to have a discussion solely on the place type map suggested changes. When we meet again for the next workshop on the 11th, we'll continue the discussion on the community residential in addition to the other components of the plan. And then based on that meeting, if needed, we can talk about additional either workshops or times to continue our conversation on the place type, on the Fort Dallas plan document. So just to overview what we talked about so far, what we talked about last meeting, we actually had that conversation about the Bachman Lake area just north of there, changing that or tweaking that suggested change to community mixed use. So we're going to continue with that direction. But we have a few other areas that we'd like to discuss, specifically in D8 and D6. So we're glad Commissioner Blair, Commissioner Carpenter are here today. All right, so for today, what we want to talk about is calling it the Redbird Distribution Center. So the suggested, as we had conversations with Commissioner Blair and others in the area, the suggestion was to change this area from community flex commercial, I put flex industry, flex commercial to community mixed use. So as we analyze that suggested change, we wanted to talk about what's happening in the region, in that area, provide kind of staff's input regarding that and get some more direction in terms of which place type that should go to. So for context, the Redbird distribution area that's highlighted in red on the map, that is just north of DeSoto. And also too, as we look kind of more regional, take a step back, DeSoto, Lancaster, that's basically a larger industrial warehouse area. Also too, in blue, that shows the inland port, the Dallas portion of the inland port. So just for context in that area, the inland port is a larger portion of the region. Dallas is only 25%. Dallas only has 25% of that larger inland port area. So as we look at the Redbird distribution area, as we look at what's happening in DeSoto, Lancaster, as we look at the portions that the city of Dallas contains or is within the inland port, I think it's important to look at how that portion just south of 20 kind of behaves as that distribution center. So as we're looking to apply the suggestion or think through the suggestion of moving away from the flex industry or flex commercial to a community mixed use, some thoughts that staff had is either keeping it flex commercial or looking at a logistic place type could be more appropriate, just because one, it's away from residential, two, it's adjacent to other similar uses in other parts of the region, and then three, because the inland port, the portion that the city of Dallas kind of withholds within the inland port is very minimal. If we were to conceptually move the Redbird distribution to the inland port, there wouldn't be any room for that to fit. So we want to think about as a city, as we grow, as that industry grows regionally, or do we want to keep that Redbird distribution as a logistics flex commercial area, or do we want to move directly to the community mixed use? So with that, I'm not sure, Commissioner Blair, if you wanted to provide a bit more explanation in terms of kind of your thoughts on that. This is your district. I want to make sure you have kind of input for the rest of the body, just based on the input that staff has in the area. Yes, please.
Well, when you look at with south of 20, north of DeSoto, Lancaster, there's a hybrid of uses, but when you're closer to the Redbird area, there's more residential uses. In fact, there's a lot of residential single family that's on Polk and Beckley Mead all the way to 35. That is nothing but total residential. and to allow intensive IR, ILI uses would be totally incompatible with what's there on the ground already. There's a school, a park, and where most of DISD students use the facility they use for their basketball games, football games, and where they graduate from. So and it has warehouses that surround it, but it's in violation of the city's Vision Zero, because there's also a lot of accidents that happen when you have residents and residential traffic and truck traffic. So to move it towards something that is more consistent with what is on the ground would be something that would blend residential, commercial. We also, that over there, we also have is Target and 1, 2, 3, actually 3, 4, 5 mega churches that are all within a mile from I-20 in this area. So to say that it's a logistics is inappropriate. To say that you can blend it would be more appropriate. So something that was less intense of 50, 60 bay warehouses, that should go in the inland port. The other challenge with that is the streets are not designed, nor are they built to handle the traffic of trucks and what the trucks bring. And so the inland port is more logistically appropriate, more logistically designed and engineered. So that's where it should be. But to move it from total industrial, you can't take what is also on the ground and tell them you gotta go, so you blend it. And that would go from some of District 3, because District 3 is right there as well when you go just as you get to Redbird. So from Redbird, you have brand new multifamily, you have existing multifamily. We're getting ready to get our grocery store. Tom Thumb is moving into that area. So you don't want to kill them before they get there and actually be able to operate. So, and the city has engineered, provided the appropriate place at the inland port. The streets are engineered to handle the traffic without breaking down and breaking up. PD 761 south of I-20 would be appropriate for all of our heavy use warehouse. So that was the thought, and that was consistent with the residents, with the multiple visits that Lawrence and his team had to visit with this area. This would be the way to have them like his team.
Thank you so much, Commissioner Blair. I think to add to what you just mentioned, so as we really want to confirm this, as we look to potentially move this to a community mixed use area, and have potentially, if these uses were to get moved to the inland port, that would be something that could happen, but it wouldn't be inside city bounds. So it would be we're kind of saying that this tax base could go to the inland port and, be a tax base for Hutchins or Wilmer or another component, another city that's within the inland ports. Just want to make sure that was something that was okay with this body as we consider if we're transitioning this to be a more mixed use type of area, where would these uses go if they decided to go somewhere else in the city? So I just wanted to confirm that that was kind of with what you were thinking about. Secondly, as we look at the pink area in this map, as Commissioner Blair mentioned, there is a DISD stadium, which is where my mouse is, in red. So as we had initial conversations with the community, I think before this IR kind of designation, before we had it be flex commercial, went all the way to the DISD district, which was also adjacent to the residential community. So what the tweaks of the map that reflected the community's feedback was, one, to reduce that adjacency to residential, and what we could do as well to continue that progression. This area could shrink if we decide to keep components of that, or it could just go entirely community mixed use. For example, the flex commercial area, where kind of south of, I believe, Beckley Mead, and just kind of cutting off at the open space, that could be a flex commercial as well, and everywhere else would be community mixed use. Just another way of kind of continuing what you just mentioned, Commissioner Blair, with adding more community mixed use and reducing the footprint of the flex commercial in the area. What we also didn't want to do is apply a logistic hub to this. I think the flex commercial seems to make sense in terms of not growing that footprint, still being compatible with what's happening south of the city, and also touching with what you just mentioned. But we just want to confirm with this body that if we do move to community mixed use everywhere in this area, just the implications of that would mean in the future in terms of tax base, in terms of where else this use could go if they decided to. Just wanted to confirm that that direction was okay with this body as we continue making those tweaks to the place type map. I'm not sure if there's any further input or feedback based on that.
It's more of just a question. So I'm looking at the aerial map and I see a number of distribution centers already built there. And some of them seem very close to neighborhoods, which I think is, there are definitely some issues with that. And as we, it seems that logistics is not the vision for the area, but one of the things that at Club, when we looked at various areas, not this one specifically, is when we're choosing place types, we want to transition away from something. In this case, I think it's, we don't want logistics to expand. What is the best way to get something else? And I think there's two sorts of competing things that we often, considerations we saw at Club. On one hand, there's sometimes an ideal place type with uses that we think are ideal for the area, but maybe a number of factors have that transition to those ideal uses relatively far off into the future, whereas there may be a place type that is still acceptable, but maybe not as ideal, but that place type may generate the transition quicker. So I know Commissioner Blair mentioned some, a Tom Thumb and other things coming into the area. I'm not exactly sure where that goes, but can you speak to sort of balancing those two competing tensions of moving away from distribution uses and whether we get there faster with flex commercial or community mixed use?
No, great question. So in terms of where the Tom Thumb would be, that's in the Redbird Shopping Mall, which is on the other side of 67, basically where my mouse is kind of hovering around. So it's not in this particular map. I'm not sure if it's on my other map. Oh yeah, so where my cursor is, it would be in this area. So going to what Commissioner Blair mentioned, along 20, the community has said, they want to make sure that that corridor is more mixed use in nature as that area starts to develop and become more mixed use in nature. They want to also have a buffer from, those uses, those mixed uses, commercial uses from their neighborhoods. And then also too, like Commissioner Blair mentioned, having a buffer from those current logistics types of uses in the area. So I think as 67 and 20 transforms more into a mixed use area, two ways to looking about it. So if we wanted to have that larger region in my mouse be just mixed use in nature. I think that's something that we should definitely look into. I think all we want to do is just think about the implications from the other component, the other cities that are adjacent to us. So DeSoto and Lancaster, their vision is to keep that as being logistics. As we look into their comp plan and their land uses, those uses aren't going to change. So what we want to do is just make sure that as the city's component, if it does transition to community mixed use, just thinking about what that area could have transformed to if DeSoto continues what they're doing. So if it stays community, if it stays flex commercial, again, it indicates there's a transition in terms of what we're looking to do as a city, but there's still some compatibility with what's happening with DeSoto, with what you said in terms of what's the quickest way to kind of get things started. I couldn't tell you directly, but I think if we wanted to indicate kind of louder that we wanted to focus on that harder transition to just mixed use in general, I think applying the community mixed use could be that indicator on the map. So that's kind of what I'll suggest or say based on your question.
Great. Thank you. That's helpful.
You're welcome.
Commissioner Blair?
In response to Vice Chair, that area is also heavily medical. The only hospital that serves the whole entire, there's Methodist, that is the north southern sector, and then there's Charlton Methodist, which is in District 8 and within this pathway. The need to transition away from heavy logistics type of use is evident when you see emergency vehicles having to go around and find alternate routes in order to get to the hospital. When you see emergency vehicles from DeSoto, Cedar Hill, Duncanville, trying to access that pathway and they can't get there. So what has been also seen happening is, if you're asking what type of use to transition from, if you don't do a mixed use where you have some type of commercial first floor and residential up, you would the natural transition would be to anything that is medical supporting. Medical offices, medical support systems, that would be an excellent use to transition from warehousing into, and it would also be more supportive of Charlton Methodist. I mean, if you guys remember, about 3 or 4 years ago, Charlton Methodist had a zoning change come before us because they completely enlarged their emergency room and they brought in more services. And those services was because of the growth that they needed in their emergency services, because of the need for that was supporting the other municipalities as well as Dallas. DeSoto also is kind of transitioning in that corridor away from heavy industrial. If you go just south near between Daniel Dale and Wintergreen, which Daniel Dale is our border line. The north side of Daniel Dale is District 8. The south side of Daniel Dale is DeSoto. And when you get between DeSoto and, where DeSoto starts in Wintergreen, there is a nice new residential development that is happening. So DeSoto in that area is also, it seems to be transitioning away from heavy industrial warehousing into something less intense. So that's just another thought when you look at that.
And I can add some context to that too as well, just so on the map, well, you mentioned Charlton, the medical center, you mentioned what's happening in Redbird, actually Parkland and more medical facilities are happening along there, and also along Wheatland, those are also medical supporting uses. Going back to what's happening in DeSoto, as they're developing their comp plan, Hampton is a key corridor for them in terms of mixed use. So as you go from DeSoto's Hampton to Dallas, in terms of being a corridor or a gateway into the city, that could be maybe more mixed use in nature. So right now it is predominantly distribution. So in terms of what that connection looks like, I think if the suggestion from Commissioner Blair, it was to be more mixed use, that could tie into some of the future ideas that DeSoto has, although a lot of their mixed use is further south, closer to their city center. They are still looking at mixes of uses, but the predominant use would be logistics on their side.
Commissioner Forsyth, followed by Commissioner House-Wright.
What would be the implications of a change like this on the existing distribution centers that are in this area?
Can you repeat the question? Sorry.
What would be the implications of changing this on the existing businesses, the distribution centers that are already there?
So there wouldn't be any implications, there wouldn't be any zoning changes in this area. So in terms of just indicating kind of the future vision that the city would like to go in this area, it would be more just indicating that if they were to rezone or redevelop, that the city would like to kind of develop more mixed use. And then anything that's industrial in nature would be more supporting versus primary.
So Lawrence, you spoke very quickly when you answered that. And
I'm sorry.
You said there would be no zoning changes as a result of this.
Correct.
Okay. Thank you. Commissioner Forsyth, please, if you have follow-up.
But it does mean that if there, a business closes or whatever, and they wanted to reopen as a distribution center, that because if we change this to community mixed use, they wouldn't be able to continue to operate in that way or to get approval for a zoning case.
So I can provide some clarity. So this wouldn't change zoning. So they could continue with that use unless they decided to change the zoning to something else. So as long as the zoning remained what it is, it will continue remaining that in perpetuity unless they decide to do a rezoning, and that rezoning would reference what the current vision is in terms of what that change should be.
Thank you. And Commissioner Forsyth brings up a critical point, and one that we hear frequently about what this plan is and what it's going to do. And so I'm hoping you can drill down a little bit. And again, you said this would not change the zoning.
100%.
And in fact, a business where the color on this chart, on this map, may change underneath them, can continue in perpetuity. And can receive a CO. Can close down and can open up 10 years later and still receive a CO, regardless of what the color is here on this map.
Right, 100%. And also, too, to add to that, as zoning changes come into the city, we'll be reviewing those zoning changes with what the future land use map indicates, and that might have us maybe update or amend the future place type map to be more reflective of what's happening or what the vision is from the market too. So it's still a living document, but yes, 100%. This wouldn't change zoning. They could continue to operate in terms of what the zoning has on the ground unless they decided to change their zoning, and then that'll be another process to come before you all to review this map and go through that discussion with what should happen on the ground.
Okay, so if we can just drill down a little bit on that. I think another thing that I hear frequently about this process and what this is going to do is, how is this plan going to be used? What is it going to, how is it going to inform? And I know that we hear the word from you guys, it's a suggestion. And exactly walk me through how this document is going to be used by staff, by future plan commission, and by future city council.
So right now, this property is zoned IR. It has some deed restrictions, but basically just those deed restrictions just say it should be industrial land uses. So if you have a warehouse and you're operating your warehouse, you can keep operating your warehouse. It can go away for, you can shut it down for 10 years. The zoning is still there. You can keep operating that warehouse. You can sell it to somebody else. They can operate a warehouse, and they can operate, they could apply to operate different type of lighter industrial land uses. That's their entitlements they have right now. This does not change any of that. Now, let's say someone buys that property and they say, I want to build an apartment building here. If we have this as a logistical place type, we would take a look and say, no, this is not a place for apartments. This is a place for more warehouses and logistical centers. So that's the vision for this area. Staff would use it as a vision to say, we're taking that in. That's part of what we're looking at. That's not all of what we're looking at, but that's part of what we're looking at where we might recommend denial for that. That would then also be part of what CPC and council would look at to say, what's the vision? The vision is a logistical center. Okay, an apartment doesn't match that vision. Again, it could change because there are a number of different factors. It doesn't say it has to be a logistics center. It can say it should be that. There are other factors you can take in. If we call this a mixed use area and someone says, I want to build an apartment building here, it would be that vision to say that does align with what that vision is. This does, this is one of the factors that we can take a look in to say we are going to recommend approval because the vision is for a mixed use area, not a logistical center. And again, because we will say this time and time again, it does not change your entitlements. It doesn't change what you can and can't do. It does not change your zoning, but it informs any future zoning changes. It doesn't say it has to be certain zoning. It just is one thing that can help inform those decisions about future zoning changes.
As you said, it would be an informed recommendation for a zoning case as it comes in, and then this body would do what it does, which is to dig down and go into the details of the site, the areas it transitioning, all the the 30 factors that we all consider in each zoning case. And one of them would be this map with its quote, its suggestion. And as we see here every 2 weeks, there's some zoning cases that align with the vision that was, that a working group come up with some time ago. Sometimes that vision is a year old, sometimes it's 20 years old. And sometimes we follow that recommendation, and many, many, many times we don't, because that recommendation doesn't align with the facts on the ground. Is that fair?
Yes, Chair, 100%. You may take a look at this and say, why are we, let's say it's the flex commercial, and you say, okay, well, flex commercial does allow warehouse, but I'm proposing a 500,000 square foot warehouse. That's not what the flex commercial, that's something that you can take a look at. Versus, oh, well, it's a 10,000 square foot warehouse. Okay, that aligns. I'm looking at this. I'm using the map as one of the things that I'm taking into consideration. But as the chair pointed out, it's not the only thing you would be taking a look at. You'd be taking a look at facts on the ground, your knowledge of the area, your knowledge of the market, your knowledge of what community members, their input and what they're telling you as well.
Thank you, sir. Commissioner Houseright?
But just to help me.
Pardon me, please.
Help me understand, though, if it is, the place type is to be community mixed use, and what's there now is distribution centers and warehouses, then technically that's a non-conforming land use.
That gets back to zoning. The non-conformity is the zoning, and this document doesn't change the zoning, so it doesn't make those non-conforming land uses. They're still, because we're not changing the law, the zoning for those. Yes, if this does change to a community mixed use, it's saying it should progress to something that's more than just those warehouses. That's not those warehouses. It doesn't say that it has to, doesn't say that they're non-conforming, just that the future vision is a little bit different than what's on the ground.
Commissioner Houseright.
Couple of questions, or a couple of comments. I completely respect the vision that Commissioner Blair is articulating. I understand, I think, the issues that she's articulating in her community. I will just say that we can do that on this place map as she suggests, and I would also say that we'll likely still get zoning cases from people coming in, the distribution center warehouse developers coming in, because they're going to bid up the land values, because that's what they think this land is, because of macroeconomic and transportation factors that impinge upon this area. And so this kind of goes to a little bit to what we did last time on the Bachman Lake area. It's fine for us to say our vision is something slightly less intense than what's there today. We just have to realize that that is an uphill battle, in that there's an economic underpinning to so much of what we do here. And I'm not criticizing those visions. I just want us to be very aware that some of those visions will not be achievable. And then you don't need to comment on that. And then let me just ask you maybe a little bit harder question about our process. Important district, important issue. I'm sure everyone on this horseshoe could spend 2 hours on our district. So why this district? Why this case? Why now? Why are we doing this right now?
Right. So good question. So as we are getting feedback from each of you all, one-on-ones, also the community members and just other factors, what we want to do is just bring up certain areas that, based on what you said, there's certain areas that if we were to change or move toward a particular direction from a place type change, two things could occur. One, if it's dramatically different from what's on the ground, thinking through the next step of that would either be some kind of zoning change, authorized hearing, that needs to happen if that's the direction that we're trying to move forward with. If not, what we want to do is make sure that the place types that we have here just they mean something.
Can't you bundle these and organize this one-off kind of, this is not a good use of the commission's time, in my opinion. I think opening up a case like this small, when we're talking about the entire city, you're not using our time well.
So
I think we're getting a little weary of it. Thank you.
Okay, no, apologies. Just to clarify too, so within this entire city, there are a few areas that we just need some clarification from. So that's all we're asking for, is just that feedback. If there's a different approach.
There's a lot of areas there's a bunch of areas we need clarification on. So why this one, why now?
As I mentioned, staff had some thoughts versus what we heard from the community and what we heard from the CBC member. Just wanted to get more feedback from the body.
Well, I think you need to be talking to the chair of the commission and others about our agenda on these times, because our time is valuable, and I don't think it's being respected in these briefings. Thank you.
Definitely, thank you.
Commissioner Rubin.
So we hopped into these key updates, I guess, at the beginning of last meeting. At the beginning of that, there was a list of maybe 15 areas that are particularly sensitive, that are worthy of, that city staff thinks are worthy of additional consideration, right?
So there are a handful of areas that are worth a discussion. I think this is one of them that we wanted to clarify.
And we're not going through every single one of those here, are we?
No, we're not. There's just a few that we wanted to talk about. 3 total. This is the second one. But just want to talk through some of those issues that we had internally with you.
And that's because they're sort of illustrative of some of the decisions that you have to make as city
Correct.
staff.
Correct.
And part of the reason for hopping into these 2 to 3 is to sort of highlight the trade-offs so city staff can have additional conversations with the commissioners individually outside the horseshoe.
Correct.
To deal with that sort of fine-tuning. So
Correct.
We're not trying to spend an inordinate amount of time on this. We're trying to sort of go through the exercise so every member of the commission can understand some of these tensions that we feel, so these conversations later on can be really well informed.
100%.
Okay, thank you.
Commissioner Kingston, followed by Commissioner Sleeper.
Thank you. I think I respectfully want to echo what Commissioner Houseright is saying. It's really difficult to pop into these discussions. We get an agenda that says forward Dallas briefing. It doesn't really say anything else. It doesn't say with regard to these areas. We don't get this handout really in enough time to do anything with it. So we're just sitting here eating lunch around the horseshoe, talking about, no disrespect, Redbird, which I personally don't know enough about to give you that much input, and I didn't get enough fair notice to educate myself about it ahead of time. So I feel like you're wasting my time. If you want meaningful impact from the entire commission, I need an agenda, I need the materials and enough time to look at it. I've been to public meetings or private meetings on Forward Dallas every night this week. I've gotten home at 11 or 12 every night this week, and now I'm here. And now we're expected to come to a number of publicly called meetings on this. I know you guys are at those same meetings and that you're working hard as well, but if we're going to get through this and we're going to have educated discussions, hey, surprise, we're going to talk about, some part of the city you may not be all that familiar with and some nuanced discussion you may not know that much about. You're not going to get very meaningful insight from me on that, and I'm probably not the only one that feels that way. So if we're going to have actual discussions about Forward Dallas, an hour here or an hour there is not, I think, a good use of our time. If you want to say, here's what we're doing, here's the next thing, here's what we want to talk about on the 11th, here's when you can expect an updated map, here's what you can expect in terms of the topics we're going to discuss, that's helpful. But here's a specific thing we want to talk about today, and you're hearing about it for the first time today, I don't find that helpful, and I don't know how much help we can provide you. If that feedback's helpful to you, great. If not, I'll go back to what I was doing.
No, thank you.
I think it's a fair point. Ms. Gillis.
I think the feedback, so Andrea Gillis, Planning and Urban Design, I think the feedback that would be helpful is, what does this body need? We're trying to piece together. We hear different things. We hear one individual commissioner that's clearly frustrated. But then we have meetings where you all say, okay, come back to us during our lunch and give us a briefing when we can fit certain things in. What do you all need? I think at the body, you all tell us how you want this to move forward, what is most effective for you, and we will do that. So at this point, it's not helpful for us to hear that we're wasting your time. We don't want to be wasting your time. So I think the body needs to decide and let us know how you would like us to proceed, what you would like us to come. We can come with a full package of this is what we recommend moving forward. We've tried to do that. We've gotten some feedback that that's what you want. We're here, we fit in an hour because you said you wanted to be able to have some time to deal with some of the smaller things. So my recommendation is you have a discussion about what you want from us, what the timing is, and how you would like to see it. And decide as a body collectively so that we can respond accordingly.
Thank you, Ms. Gillis. I think the commission and the commissioners bring a fair point. This is a lot to consider. It's complicated, it's big, and I think to get input from us, we maybe need a little bit of a heads up as to the detail of what we're going to be discussing. And I know that sometimes it's difficult for you. You didn't know today if you were going to have 10 minutes or an hour. In fact, we just decided right before lunch. I honestly thought you were probably going to get 20 minutes. It ended up that you got an hour. So you do have to improvise a little bit, but I think Commissioner Kingston and Housewright are on point where the input from us, we need a little bit of heads up. I know I do because I need to do my homework and read and think about it. And so maybe, especially for our meeting next Thursday, let's have a detailed agenda, exactly what we hope to get to, what we want to consider, and what we want to talk about. We're running a little bit short on time, Commissioners. I think we have Commissioner Sleeper.
Well, I know we're running short on time, and I hope you'll forgive me if I'm rehashing ground that I hashed last week. But just as an example, we talked about last week, or I talked to you two individually about an area that you show on your map to be community mixed use, which is a fairly low density zoning, even compared to what's on the ground today. And if you add on what's been approved by this commission, it's a much higher zoning category, much more dense zoning category than this category. So I guess the thing that it made me realize is it's really important to interact with you guys now so that we get that colored the right way on the map, or future land use is going to be a real difficult problem if we were able to follow through on the much more dense zoning that we had in mind. So I guess what that's saying in a long way is I have a feeling, the feeling I had before was this map was a general indication of where the plan might go, but I never really felt like if this map was not colored the way I think it should be, or the way that aligns with my future plans, that I really better start the battle earlier and talk with you guys and make sure that it has the right nomenclature on there, or otherwise, when I go to do what I was originally planning on doing, I may have a very tough time doing that. So you're nodding your head, which I'm gathering is an affirmation. If that's correct, I just think it's incumbent upon us to make sure that people that are in our districts understand that, and understand that it's really important how this map gets drawn, or you may find it difficult to do what you want to do in the future.
No, 100%. And just to kind of step back in terms of the ask from staff in the last few months, we've requested, one-on-ones with each of you all to talk through your district, the place type map, and kind of what you see there. What we want to do too, as we have these meetings, is connect the dots in terms of the conversations that we're having with each of you all, instead of having one-off conversations, create a place type map that has something that y'all have never seen, just to make sure that you're seeing what's happening with the entirety of the feedback with each of you all. So as we continue those discussions to talk about what's happening in your district, if there's some issue areas that come up that could get more feedback or more input from the body, that's what we'd like to see and have happen. That's the purpose of kind of coming here. But I think what Commissioner Kingston, Commissioner Housewright mentioned, I think we can do a better job of kind of crafting it to help you all get that input for us. The previous body that we're within, they suggested doing it a particular similar way. I think this one needs to be tweaked a bit, just to provide you all with enough time, with enough ammunition and knowledge to give us the information that we're looking for.
Commissioner Herbert, followed by Commissioner Wheeler.
I'll be quick. First, thank you for bringing up this area for my district, District 8, District 1. A lot of us touch this issue, and it's huge for our community, the Black and brown community. The whole focus around this plan was around equity and being equitable to the people who we've forgotten over the years. That's been a huge part of our plan as a city, as employees, citizens, from the mayor's office to the city manager's office. So I do think that this is a serious issue, and we would love to have the input from other people, because emotions are really high in our community about industrial next to housing. This area stretches across 20, which is 50% of the southern sector. So the importance of this conversation is high for me and the people that I deal with at my meetings that are coming up, as are other conversations that are important for other parts of the area. That being said, those conversations are helpful to me to go back to my community. In regards to the plans themselves, I've seen 5 large warehouses go up in my area, and at each case, a citizen came up and said, this is against the Southwest Dallas plan. They were approved anyway. So I just find it interesting that these conversations happen, and there's so much strength put behind these area plans, and then the southern sectors uses their area plan as a tool, and they're still rejected. So as we move forward, let's keep equity in mind. Preparation, yes. Time to study, yes. Understanding the areas, yes, I get it all. But the importance of this conversation is really high for me and my community. Thank you.
Thank you, Commissioner.
Commissioner Wheeler.
I had a previous conversation with city staff this morning, and I did keep city staff appraised of some things that happened this week. That I met with the community group who is having a hard time with place types, which was the Joppy community. And I took the time to explain some things to them, and I work really well with calling Andrea and Patrick and to get those informations out. I think that was really missing it, and I can understand that it is time consuming, that we always don't have updates. But I also think that I found out this morning that this body used to take tours in the morning. And if we can take we might need to take some tours as a body to these different areas and understand why it's in high regard. People again, north of 30 really understand what they're looking at and south of 30, we have people that don't understand, so it's misconstrued on what is being asked or what the place types might be, what our community can and what does it look like in the future, because they've never planned. Everything that has been done or for them has been planned by the city or for someone that is not native to their community, where we're behind the buck. Again, we know I'm 47 and I'm in college for urban planning because I never knew what urban planning was. And so just imagine the other people that that don't understand this. So getting us information earlier will really help. The reason that we're looking at these areas maybe can help other commissioners understand, because again, the community did not plan. The people who live in the community did not plan the distribution area, the inland port. They had no say. And if they did, they would have been around and saying, this is what we need, this is what we don't want. Is this going to cause an environmental issue? Any of those things. So I do agree with some of it that we need to get that out on what those briefings are going to look like and be inclusive. And we need to cross border lines, because this body as a whole votes on everything, not just one commissioner. And we need to cross some border lines to understand why the Southern District is always in kind of in an uproar about what this looks like. So do we need to know? Because again, we're very uneducated on even what Forward Dallas is. I get to have a special place because Forward Dallas is working in conjunction with area plan. So I was a chair on the area plan and got to get some learning firsthand with city staff. So get the information out a little easier, but I do understand why this is very important, because the inland port is not just controlled by the city of Dallas, it's controlled by Wilmer, Hutchins, DeSoto, Duncanville, Lancaster. And when you go to crossing lines, Dallas has to do their part on that 25% to ensure that the citizen of Dallas is protected first and foremost from environmental issues. And then what does it look like? Because it do offer great jobs, but we don't want it to be at a cost of our community.
100%. Thank you so much, Commissioner.
Any other questions, commissioners? Thank you very much, gentlemen. Commissioners, that is 12:31, and that concludes the briefing of the Dallas City Plan Commission. We'll go ahead and begin the hearing now.
Thank you.
Thank you. Ms. Pacina, can you please start us off with the roll call?